Well, good morning. Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, LaMattia, Menendez, Middleton, Parker, Perry, Schwartner, Zaffarini, Paxton, Hughes.
Present.
Gotcha.
And a quorum is present. Good morning. We'll begin with Senate Bill 1556. The chair now lays out Senate Bill 1556 and recognizes its author, Senator Parker, to explain the measure.
Thank you, Mr. Chairman. Members, appreciate the opportunity to come before you this morning with Senate Bill 1556. On June 27, 2022, the United States Supreme Court ruled 6-3 in Kennedy versus Bremerton School District, finding in favor of a high school football coach, Joseph Kennedy, who sued Bremerton School District in Washington State because his contract was not renewed in response to Kennedy praying on the field immediately following games. The court found that the free exercise and free speech clause of the First Amendment protect an individual engaging in a personal religious observance from governmental reprisal, and the Constitution neither mandates nor permits the government to suppress such religious expression. The court's decision is summarized by this key quote by Justice Gorsuch in the Kennedy opinion, quote unquote, "Respect for religious expressions is indispensable to life in a free and diverse republic. Here, a government entity sought to punish an individual for engaging in a personal religious observance based on a mistaken view that it has a duty to suppress religious observances, even as it allows comparable secular speech. The Constitution neither mandates nor tolerates that kind of discrimination," end quote. Grounded in the Kennedy decision, Senate Bill 1556 codifies the right of school employees to engage in personal religious speech or prayer while on duty. As established in Kennedy, any infringement shall be analyzed under strict scrutiny, requiring the infringement to be one necessary to further compelling state interest, and two, narrowly tailored using the least restrictive means to achieve that compelling state interest. We in Texas should follow the Supreme Court's lead and protect the right of teachers to express their personally held religious beliefs. And with that, Mr. Chairman and members, I conclude my formal layout. Thank you again for the opportunity to come before you with 1556, and I know we've got some excellent witnesses today here as well.
Thank you, Senator. Members, any questions for the author? Very well, we'll open testimony and invited testimony. The chair calls the Honorable Matt Krause, testifying for Senate Bill 1556. Representative Krause, welcome. Get comfortable there. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. Thank you to the committee for allowing me to be here today. My name is Matt Krause. I'm here on behalf of First Liberty Institute, and we are for Senate Bill 1556. Senator Parker laid out the bill perfectly. What this is a recodification of a Supreme Court opinion last summer in Bremerton versus Kennedy, where Coach Kennedy was kneeling on the 50-yard line. After every game, he was grateful to the Lord for allowing him to be in the position that he was in, investing in the lives of these young men. Took a moment to pray and thank God for that opportunity to do it at the 50-yard line. The school district said you can't do that. Multiple district courts and even a court of appeals said you can't do that, but the Supreme Court said, no, you absolutely have the right to do that. And so Senate Bill 1556 is a codification of that case law into Texas statute. And so we're taking that ruling, we're taking that holding, and putting it into Texas statutory law. And so as the senator laid out, it's the same test we have under the current RFRA statute, the Restoration and Freedom, the RFRA, Texas RFRA. And so I think you'll find that we have a lot of familiarity, we have a lot of knowledge of what this kind of statute, how it acts and how it interacts with current Texas law.
Thanks, Representative. Senators, any questions for the witness? Thanks for being here.
Thank you, Chairman. Appreciate it.
Wonderful.
Thank you, Senator. Keep up the good work.
Thank you.
And we'll open public testimony on Senate Bill 1556. The chair calls it Sean Hall Laquona, and Denise Seibert. Sean Hall Lacona and Denise Seibert. And those are the only two witnesses we have registered on, for, or against Senate Bill 1556. So if anyone else wishes to, please register at the kiosk just outside the chamber.
Either way. Mine's short.
All right, welcome back. Introduce yourself again and give us your testimony.
Good morning. My name is Denise Seibert. I am representing myself. I support SB 1556, freedom of religious speech and prayer. Thank you, senators, for allowing me to be heard today. The Bill of Rights states plainly in Amendment 1, Congress should make no law respecting an establishment of religion or prohibiting the free exercise thereof. Again, Congress shall make no law respecting an establishment of religion or prohibiting the exercise thereof, or abridging the freedom of speech or of press or the right of people peaceably to assemble and to petition the government for a redress of grievances. We already have a law, but now we add another. We should uphold the laws we already have. But schools have disregarded our laws and our freedom of religion and even taken several to court for practicing their belief. So here we are reestablishing and reinstating the Bill of Rights, so employees of a school district or charter school may have the freedom we are guaranteed. Schools don't dictate our beliefs, and we don't stop our values and beliefs because we step on school's property. We used to pray at school and school events such as football games, but now we're sued for practicing our freedom of religion. But once again, we call the people to prayer if there's a school crisis or danger at our school. School districts can't make up their mind. The Bill of Rights has stood since 1776, but now we're taken away by people who don't know our basic rights now. So here we are. Let's uphold the laws we already have. Let's uphold the laws we already have. I'm very concerned. I support upholding the laws we already have. But if I have to, I support SB 1556, the Bill of Rights that upholds our freedoms of religions and speech and prayer. Thank you, Senator Tanner.
Thanks for your testimony. Good morning. Welcome back. Introduce yourself again and give us your testimony.
Thank you. My name is Sean A. Hall Lacona, also known as Liberty, Justice, Truth. I'm here on behalf of the Kingdom of God Almighty. I stand for SB 1556. Chairman Hughes and the State Affairs Committee of the 88th Texas Legislature, I hope you are having a good day, ready to have received understanding exceeding much. For the people with largest of heart, even as the sand that is on the seashore, I come for the promised, having received wisdom and understanding exceeding much. Ancient of Days has answered my question through the advocate, saying, little children, keep yourselves from idols. Amen. Article 3, Section 3, Paragraph 2, 21st word of our Constitution, blood. I will continue to speak truth in blood forevermore, they having found no fault in I. You best praise because illegitimacy is unable to prepare federal income tax returns. God even taught through the Ark of the Covenant how to be submitted in love, for which all rights, privileges, and honors are known by all men, tribus unum, counselors having mens rea. Love reigns in justice. I am recognized as only one. Will someone from the government send an official notice to my children? I am still married. My word given was sufficient. I am necessary to further a compelling state interest, narrowly tailored, using the least restrictive means to achieve that compelling state interest. Thank you kindly.
Thank you for your testimony. Senators, any questions for either of our witnesses? Thank you both for being here.
Thank you both so much.
The chair calls Mary Castle. Mary Castle. And I'll ask now if there's anyone else wishing to testify on, for, or against Senate Bill 1556. Ms. Castle, welcome back. Introduce yourself. Give us your testimony.
Good morning, Chairman Hughes and members of the committee. My name is Mary Elizabeth Castle, and I'm the Director of Government Relations for Texas Values Action. Texas Values Action is very supportive of this bill by Senator Parker because it stands for religious liberty. We work in concert with First Liberty Institute in Plano, Texas, that works on religious liberty issues, and Texas Values actually filed an amicus brief in the Coach Kennedy case. That case was very important in establishing First Amendment rights of employees at public schools because it changed the burden to be on the government. Instead of an employee having to prove that their religious liberty rights were violated, now the government and the school had to prove that they had a reason for denying that employee their religious liberty. It also struck down the arduous lemon test. That was the three-pronged test that was infamous in religious liberty cases, that you had to meet several of those requirements in order to prove that your religious liberty had been violated. But now, for the first time, with the Coach Kennedy case, that has been struck down. What we're doing today in this bill would not be doing anything new. It would just be in addition to what we codified here at the legislature in 2007, which was just some reinforcement of student religious speech. We're so thankful for Senator Parker for bringing this bill. Everyone understands Coach Kennedy's circumstance as one that was basically taking his opportunity to engage in something that was important and dear to him, which is expressing prayer on the 50-yard line, doing something that all of us should have the right to do, especially in the United States of America. And we want to make sure that all school employees, whether they're a coach or a teacher, have that right to pray and express their religious beliefs in their public place of employment. So thank you so much for this bill.
Thanks for your testimony. Members, any questions? Thanks for being here. So did you register at the kiosk outside to testify on this bill? Very good. Go ahead and after you testify, check with Ms. Babin, fill out a card just to make sure, because for some reason we didn't get it. Of course, we want to hear from you, but we want to have the records accurate. So introduce yourself again and go ahead.
Thank you. Thank you so much. My name is Gregory Porter. I'm acting and speaking on behalf of Texas for Liberty and myself. I testified or signed up to testify against the bill, not because I don't appreciate the bill, and I think this is a really appropriate subject matter, and I completely agree with religious freedom. The concern that I had about the bill was the notation that it makes regarding an exception that the compelling state interest might overshadow this. And again, that language, just looking from a legal perspective, might marry precedents from a Supreme Court case. But my concern is right now we have federal agencies that are labeling parents as terrorists. And so from a federal perspective, we have an opposition to free speech that could be countered by this exceptional language. My humble opinion is that you actually just leave the section 22.012 without sections 1 and 2 below it, so that there is not some carve out for a compelling state interest or a subjective opinion by the state to be able to overcome this natural right to free speech. And the last thing that I'll say is I'm seeing a lot of legislation from my perspective that's concerning, because we have constitutional rights that are defined in a very general way, which I think are very important. When we start to create exceptions, then we're actually limiting our rights. When we start to use specific language regarding what should be very broad and general rights, restrictions and specific language ought to be used toward governments and institutions and corporations. Very general language that does not require any restrictions should be applied to individual rights. So I support the bill in its concept. I think it's a really, I'm very grateful that this has been put forward. My friendly suggestion would be that we remove sections 1 and 2, and if that conflicts with Supreme Court precedent, I'd be interested to understand how that works. But I think it's very important that we do not leave subjective language that allows the state to determine what is a compelling interest to compete with our right to free speech. Thank you.
Thanks for your testimony. Members, any questions? Thanks for being here. That concludes public testimony on Senate Bill 1556. Public testimony is closed. Bill's left pending at this time. The chair now lays out Senate Bill 1711.
Thank you, Mr.
Senator Perry,
Chairman.
recognize Senator Perry to explain the measure.
And members, during the 86th session, Senate Bill 18 passed out the legislature with overwhelming support, helping to ensure that free speech is protected on college campuses. Although Senate Bill 18 clarified that students cannot be punished for expressing a political, religious, ideological, or academic viewpoint, the bill did not clearly provide similar protections for student organizations. November of 2022, the Federalist Society and Christian Legal Society at Texas A&M University School of Law hosted an event called Religious Liberty, where it stands and where it's going. The student organization invited leaders from Alliance Defending Freedom and First Liberty Institute to come and speak. Shortly thereafter, 19 of 34 student organizations on campuses condemned the event and publicly shamed the student organizations for attempting to host a discussion about religious liberty. Currently, 17 states have statutory protections that allow organizations to, 1, require that members adhere to the organization's sincerely held beliefs, 2, comply with the organization's standard of conduct, and 3, further the organization's mission or purpose. Unfortunately, Texas does not have those same protections for the student organizations. Mr. Chair, there is a sub. Senate Bill 1711 grants these protections to our college organizations and helps ensure that all student organizations can continue to represent their sincerely held beliefs. The sub removes the ability of the bill for a party to recover damages, court costs, or attorney's fees. The bill will allow parties to obtain a declaratory judgment or injunction. Thank you for consideration of this bill. This is happening across the country numerous times. We've seen it play out in Iowa, Kansas, and California specifically.
Thank you, Senator Perry. There's a committee substitute which is now before us. Senator Perry has explained it. Members, any questions for Senator Perry on the substitute? Very well. We'll open testimony, and the chair calls Lance Kinzer. Lance Kinzer. Welcome. Get situated there and introduce yourself. Give us your testimony.
Thank you so much. Thank you, Mr. Chairman, members of the committee. My name is Lance Kinzer. I'm here on behalf of First Amendment Partnership, where we have the privilege of working with some of the nation's largest faith communities on issues of common concern. We've worked very closely with a number of campus organizations, particularly faith-based groups like Navigators, Cru, InterVarsity, Christian Legal Society, who was mentioned previously. And as the senator rightly said, across the country, student organizations have been punished based upon their beliefs, and particularly based upon requiring that those who would lead those groups or choose leaders of those groups hold to the beliefs that the organization was founded to promote. And so you might think of this as a situation where maybe in a context that's familiar here, imagine if the Democratic caucus was required to allow a Republican to serve as their leader. It comes up more commonly in circumstances where, say, a Baptist student union group wants to guarantee that those who teach their Bible studies hold to Baptist theology. This bill is broadly drafted. It does not favor one particular viewpoint over another. It protects all groups that are belief-based, that wish to have standards for who can lead and speak on behalf of these organizations. Now, you may remember, especially those of you who have been here for a bit, that in 2019, Texas took an important first step by limiting viewpoint discrimination with respect to campus organizations. However, there are kind of two distinct issues that arise that often lead to litigation. One of those is just flat out viewpoint discrimination by a university towards a student organization, but very commonly, so commonly that I'm on a call every week with general counsel for large campus ministries around the country talking about this issue. Very commonly, universities will say that in order to be recognized as a campus organization on campus, you can't require that your leaders share your beliefs. How does that arise? Normally speaking, what happens is these organizations will submit their constitutions. They'll say that we were founded for this particular purpose, this particular ministry purpose, and the university will come back and say you need to remove that requirement in order to be recognized. That leads to litigation. The Iowa situation that was mentioned was very much like that. It started with a small evangelical group, Business Leaders in Christ. It was told they couldn't select their leaders. Ultimately, that case went all the way up to the Eighth Circuit. The Eighth Circuit not only found in favor of the small campus ministry, they actually said that there was that qualified immunity didn't apply, so that individual members of the university administration who had engaged in the constitutional violation could be held personally liable. I'll just conclude, because my time is up, by saying that the purpose of legislation like this in the 17 states where it has been passed is to prevent litigation, to provide a clear standard so that we don't have to go to court to litigate these cases. And we found that it's very successful in those 17 states to simply be able to tell general counsel at universities, hey, there's a clear standard here, let's not litigate, let's just do the right thing. So I appreciate the committee's time. Thank you.
Thank you for being
so
here.
much. Members, any questions? Senator Perry.
I'd say spoken like a former legislator from the Kansas,
Yes, sir.
great state of Kansas. So thank you for being here. Thank you for your position. You raise a valid point that setting aside the mission, belief, and organizations being able to be established on both sides or all sides, but it's kind of tort reform, right? kind of promotes less.
So I would, Senator, I would say this. You know, the groups that I really work with the closest. So, for example, InterVarsity, they at the University of Iowa, when they were told they couldn't have leadership standards, they went to federal court under Section 1983, and they won. And ultimately, their group plus the judgment in favor of the Small Business Leaders in Christ group was close to $2 million that the taxpayers paid. But I've talked to InterVarsity even about taking out the damage provision in your bill, and they're still strongly in favor of this because they can litigate these cases and usually win, but that's not what they want. They just want to do the service that they're doing on campus, minister to these kids on campus, do so without controversy. And so what they like is in states that have clear standards, they don't have to litigate. And so it's important to have the ability to get injunctive relief, but we think that what will happen is that you'll just, it's like tort reform.
Thank you, Madam Chair.
Thank you, Senator Perry. Members, any other questions? Thanks for being here today. Appreciate your testimony. The chair now opens public testimony and calls Sean Hall Laquona and Mary Elizabeth Castle. Appreciate you being here today. And we'll start on this side and make our way across this way. Thank you so much. Please state your name for the record and then give us your testimony.
Thank you. Yes, my name is Sean A. Hall Laquona, also known by Liberty, Justice, Truth. I am here to testify about the victory of our Lord Jesus Christ in the land, on the land, because he has a dream that he's fulfilled already. I'll just show this. I don't know where this came from, but it did not come from me. But I appreciate the opportunity, Chairman, Vice Chairman Paxton, and the State Affairs Committee of the 88th Texas Legislature. I hope you are having a good day. I will continue to speak this truth forevermore. Love reigns in justice. I stand on SB 1711, knowing in God we trust, hoping that the one soul working in the clerk's office of the Texas Supreme Court did file the last document of our winning case, because E tribus unum is a federally protected mark for which all rights, privileges, and honors are known by all men. In good faith, I have obeyed law, he upholding my oath provided by the law of the state of Texas. But there is now not one member of the profession able to prepare federal tax returns. an institution of higher education continues violating Christ, notwithstanding Article 3, Section 3, Paragraph 2, 21st word of the federal Constitution, no hospital ever healed any member from cancer. Almighty defeated death on the cross, making the way of life. He created them male and female and blessed them and called them mankind in the day they were created, saying, "Little children, keep yourselves from idols." Amen. Thank you for listening and heeding the word of the Lord.
Thank you for your testimony. Please state your name for the record and give us your testimony.
Good morning, Vice Chairwoman Paxton and members of the committee. My name is Mary Elizabeth Castle. I'm Director of Government Relations for Texas Values Action, and I'm testifying in favor of the bill. Texas Values worked hard in the 2019 session on First Amendment legislation that would have protected viewpoint discrimination on campuses in relation to speakers, but the work is not quite done. Groups still need protection for just being the core of who they are. Recently, the Biden administration proposed a rule that would rescind the Trump administration's protection of religious freedom on campuses. That rule would basically deny federal funding to colleges that restrict the activities of religious organizations on campuses. And we know that this was done with the intent to leave them vulnerable to attack because the Biden administration did not propose any alternative to this. According to the group FIRE, which is the Foundation of Individual Rights in Education, as of 2023, almost 14% of public universities maintain policies that substantially restrict students' First Amendment rights. Many members of my team know this to be true, as we've all been leaders of different types of groups on our campuses, whether it was at the undergraduate level or graduate level, where they represented viewpoints such as pro-life or religious freedom and struggled with fighting public universities on them either having us not have our voices heard or forcing that group to adopt something against its religious belief. College campuses are a prime place for students to learn how to express their beliefs, whether religious or not. And if there's a particular group on campus that holds religious beliefs and they require these tenets for their members, they shouldn't feel like they have to deny those or go against those beliefs just because of a campus policy. So we are very much in favor of this bill. Thank you.
Thank you so much for your testimony. Members, are there any questions for the witnesses? If not, thank you so much. Appreciate you being here today. Is there anyone else wishing to testify on, for, or against Senate Bill 1711? Seeing none, public testimony is now closed, and the bill will be left pending, subject to the call of the chair. Chair lays out Senate Bill 2186 and recognizes its author, Senator Zaffirini, to explain the bill.
Thank you, Madam Chair. Madam Chair and members, Senate Bill 2186 relates to the manner of executing certain anatomical gift records. Members, current law allows persons physically unable to sign a record indicating their desire to become organ donors or modify their donor status to direct another person to sign on their behalf. Executing such a record, however, requires two witnesses, one of whom must be a disinterested party. This places a burden on persons with disabilities who have limited contact with persons outside their family units. Generally then, Senate Bill 2186 simply would permit a notary public to verify another person's signature to issue, amend, revoke, or refuse a statement of anatomical gift on behalf of a donor who physically cannot sign.
Thank you, Senator Zaffirini. You're recognized to lay out the committee substitute. There's no committee substitute. Then I unrecognize you for that. Thank you. Members, are there any questions for Senator Zaffirini about the bill? All right. The chair calls Meredith McIver. Thank you so much for being here. And would you please state your name for the record and then give us your testimony, please?
Yes, thank you, Madam Chair Paxton and members of the committee. My name is Meredith McIver, and I'm an estate planning and probate attorney. I'm here on behalf of the Texas Real Estate and Probate Institute, known as TREP, which took over the legislative efforts of the Real Estate, Probate, and Trust Law section of the State Bar. I'm speaking in favor of SB 2186. We appreciate Senator Zaffarini for introducing this bill. The Health and Safety Code allows a person to make anatomical gifts for transplantation, therapy, research, and education. The code also lists certain other individuals who can make or revoke anatomical gifts on behalf of another. These individuals include an agent under a medical power of attorney, a guardian, or a parent of an unemancipated minor. Any of these individuals may make a written anatomical gift, and the writing is required to be completed before 2 witnesses or a notary. A revocation of an anatomical gift is required to be completed the same way. However, if any of these individuals are physically unable to make or revoke a written gift, someone acting at their direction may complete the writing before 2 witnesses. The option to execute a writing before a notary is not currently available. SB 2186 seeks to allow that option. Additionally, the bill makes a correction to Chapters 692 and 692A of the Health and Safety Code. Chapter 692 was repealed in 2009 and replaced by Chapter 692A. However, that same year, Section 692.003D was added to the old statute. It is currently the only provision under Chapter 692. This bill moves the remaining language from that section to Chapter 692A of the Code. This does not change existing law, but simply moves it to the correct chapter of the Health and Safety Code. TREP believes that this will reduce confusion for practitioners and the public. Thank you for your time. I'm open for any questions.
Thank you for your testimony. Members, are there any questions for the witness? Thank you for being here today.
Thank you.
Chair now opens public testimony on Senate Bill 2186 by Senator Zaffarini and calls John Seago. All right. Is there anyone else wishing to testify on, for, or against Senate Bill 2186? Hearing and seeing none, public testimony is, Mr. Seago, come on in. You're 1 word away from closure there, so good timing. All right, go ahead and state your name for the record and then give us your testimony, please.
Yep. Madam Chair, members, thank you for the opportunity to testify. Just had to run from another room. So my name is Dr. John Seago. I serve as the president of Texas Right to Life, and I'm here in opposition to 2186, Senate Bill 2186, with a couple of concerns. So Texas Right to Life...
Could you pull the microphone toward you just a little? Thank you.
So Texas Right to Life is a pro-life organization. We work to protect innocent human life from fertilization until natural death. Also, a huge part of what we've done in the last 10 years is served as patient advocates, actually representing vulnerable patients in their hospitals. And so we see a lot of this up kind of firsthand from what's going on in Texas. There's no debate that organ donation can be life-saving and a positive social good. However, there are several ethical concerns that this committee must not neglect. And our concern is over the expansion of using the internet, using a website to authorize donation. And I know that this is a debate that the committee's had multiple times. But overall, we're concerned that this bill does jeopardize a couple of principles when it comes to the respect for patient autonomy and acquiring fully informed consent. This bill, by moving some of the language over, it does waive some of the patient protections that we have for donors. Specifically, whenever we kind of get into the language about websites and requiring, it waives these requirements to have witnesses and oversights of a notary public. As advocates, we've seen firsthand Texans be confused about what their donation status is or the importance of their donation status. And so we're concerned that kind of moving some of this language over and kind of strengthening using websites to authorize donation doesn't live up to fully informing patients about the decision that they're making.
Thank you for your testimony. Members, are there any questions for the witness? Senator Birdwell, you're recognized.
Thank you, Madam Chair. John, good to see you. Is there any, can you recommend an amendment or adjustment that Senator Zeffrini could make that would make the bill we certainly get her intent, what we're trying to do, but your cautions are worthwhile. Is there a recommendation you can make?
So our concern is that practically your organ donation status does affect healthcare options that are presented to you in the ICU. And this is, in bioethics, we talk about this as being over-interpreting documents. And so we have seen firsthand in the ICU a donation status being over-interpreted as the kind of position that a patient doesn't want to continue life-sustaining treatment. And so
you've seen it basically function as a DNR?
Not necessarily a DNR, but a request to withdraw life-sustaining treatment after a short amount of time. And so our concern is that if you're just talking about on a website, making a decision on a website, you don't have the standard that we usually do when you make medical decisions with a physician in the room, to asking them questions, hearing context, and that physician has a duty to make sure the patient is fully informed and that they can make a judgment call, okay, this patient knows what decision they're making. You don't have those protections when you're doing something online.
Okay. Thank you, Madam Chair.
Thank you, Senator Birdwell. Members, any other questions for the witness? If not, thank you so much for being here. We appreciate it. Is there anyone else wishing to testify on, for, or against Senate Bill 2186? Hearing, seeing none, public testimony is now closed.
Thank you, Madam Chair and members.
And Senate Bill 2186 will be left pending, subject to the call of the chair. All right. Chair lays out Senate Bill 252 by Senator Alvarado and recognizes Senator Alvarado to explain the bill. Thanks for being here.
Good morning, Madam Chair, members, thank you. Senate Bill 252 aims to allow certain individuals to become licensed Texas peace officers. Specifically, this will allow permanent residents, known as LPRs, who have completed at least 2 years of military service and have received an honorable discharge, to apply to become licensed as Texas peace officers. Law enforcement agencies across the U.S. have faced significant challenges for recruiting, retaining, and hiring peace officers. Combined with retirement rates, our law enforcement agencies face a storm of challenges. Fortunately, a promising pool of recruits is available but has yet to be tapped. Military veterans bring skill sets and life experiences from their services that differ from and are often exceed without military training. By lifting the requirement for citizenship for peace officers, this is allowing some flexibility to our police departments. We are joining many other states who have passed laws similar to this one, states like Colorado, West Virginia, Louisiana, North Dakota, Oklahoma, and Tennessee. Madam Chair, we do have a substitute.
Thank you, Senator Alvarado. The chair sends up the substitute for Senate Bill 252 and recognizes Senator Alvarado to explain the difference between the two.
The committee's substitute for Senate Bill 252 allows the Texas Commission on Law Enforcement, better known as TCOL, to license those eligible LPRs whose only disqualification is that they are not U.S. citizens. Importantly, this bill does not force any local law enforcement agency to hire them. It simply gives them the option. After consulting with TCOL, the committee substitute expands the eligible licensure to all TCOL licenses and clarifies that political subdivisions may employ these LPRs once they are licensed. Madam Chair and members, we have overwhelming support from law enforcement. You're going to hear from some of them today, as well as veterans organization, and we have been working with them to get their support. Also, TCOL is here as a resource.
Thank you, Senator Alvarado. Senator Birdwell, you're recognized.
Thank you, Madam Chair. Thank you, Senator Alvarado. Is there an intent? Let me back up. An individual that is lawfully present may join the armed forces. Most soldiers I've had, granted my experience is somewhat dated now because it's been a couple of decades since I left uniform, but most folks that serve in our military and then seek citizenship status, having lawfully been afforded a green card and then lawfully joining the armed forces. In fact, there's an expeditious means of citizenship due to that military.
That's correct.
Is the intent for individuals that would fall into this program, is the intent for them to seek citizenship? Because I'm still of the belief that you ought to be a citizen. But I'm prepared to fast track military veterans. But is there a requirement in your bill that says you must seek citizenship? Because you could have individuals that just seek lawful residency and they seek that for decades without seeking citizenship. And then you could find your circumstance where the LPL becomes a Class 1 peace officer, Class 2, continues to work their way through the various certifications of law enforcement, never having achieved or desired citizenship. Mm-hmm. So I'm of the sense that there should still be a citizenship requirement in some capacity. So I'd like to work with you on this.
And that's perfectly acceptable to us. We could include language that would include some verifiable pursuing of full citizenship.
Or do you put something that, I'm just thinking out loud with you, but something that says, okay, you must apply for citizenship, because you can have the green card without applying for citizenship. You must apply for citizenship, and then you can be commissioned, and then do you remain a Class 1, Class 2? You can't go beyond that. You can't go beyond that until citizenship is granted. So something that puts that marker of citizenship down before there's a level of seniority in a law enforcement position. Mm-hmm. That's my sense of the requirement. I know what you're trying to do, and I think it's a laudatory aim, but I don't think we should just simply waive citizenship in perpetuity.
And we've had discussions about that, and we're certainly open to that. One thing that we considered was including language to make sure that that the LPRs, that it was verified that they were pursuing full citizenship. And you're right about those in the military. We have about 35,000 non-citizens in the military right now. Almost 8,000 enlist every year, and we know that their citizenship process can be expedited. So we're happy to work with you, but I think it's a good suggestion.
Yeah. Thank you, ma'am. Thank you, Madam Chair.
Thank you, Senator Birdwell. Members, any other questions for the author? All right. Thank you, Senator Alvarado.
Thank you.
The chair opens public testimony and calls Ray Hunt, Mitch Fuller, and David Barton. And if there is anyone else wishing to testify on, for, or against, if you want to go in and kind of make your way down, and we'll have you after this panel. Thanks so much for being here. We'll go from this side to this side, and appreciate your testimony today. Please state your name for the record and give us your testimony. 2 minutes, please.
My name is David Batten. I represent the Harris County Deputies Organization, FOP 39, and we're speaking on behalf of the bill today. Law enforcement is struggling right now to find qualified applicants to join in and become law enforcement officers. One of the things, at least when I served in the military, you have somebody that serves and protects your country and stands alongside of you. There's no reason why that they can't serve and protect the community that they live in. A number of people, you wouldn't want somebody from Canada to come in and go, well, you can't become a police officer just because you decided to keep your Canadian citizenship. Because of the amount of time and effort that does become necessary to have a permanent resident alien green card, they're well vetted. And that's one of the issues that it makes no sense to say you can't be a police officer with all the vetting that you've done, become a permanent resident alien. One of the bad things about that status, if you decide to maintain it, is that you commit some infraction that you are eligible for deportation at that point in time. That's gone on for many years. And when I represented people years ago on immigration issues, they had been here for a long time and committed a minor infraction and didn't know they were subject to deportation. There's a lot of other issues. You can control this. I understand the concerns of the committee regarding moving up in rank. That doesn't seem to be a problem in the military. And we'd ask the court to, or this commission to approve this bill. One, that especially with jail personnel, there's no reason we can't have people in there and they're controlled. The number of people that we're lacking in the jail is significant. Do you have any questions?
Thank you for your testimony. Members, any questions for Mr. Batten?
Batten.
Yes, thank you. All right, please, thank you for your testimony. Appreciate it today. Please state your name for the record and give us your testimony.
My name is Ray Hunt. I'm the Executive Director of the Houston Police Officers Union and a police officer for the last 33 years. I'm in the minority up here because I'm not a military person. However, I've been wanting this bill for at least the last 5 sessions. I think it is a very fair bill. I was ignorant to the fact of what an LPR was for a long time. It's not someone who ever came here illegally. These persons all did it the right way to get here completely legal. And then for them to have the highest respect for veterans, but especially those who were not born here and still choose to go and fight for our country. This bill would be a moot point if I'd got my way about 5 years ago when I met with our 2 state U.S. senators asking that an honorably discharged veteran who's a legal permanent resident automatically becomes a U.S. citizen upon an honorable discharge of the military. And I still wish that they would consider that because I think it shows where your heart is whenever you choose to go fight for this country. So I really hope that we do this. It is, I'm told that the Dallas Police Department has a number of folks who have applied, met all qualifications with the exception of this. And my understanding is this was only a TCO rule from about 2001. I don't believe this has ever been in state law that required it to be a U.S. citizen. But I do hope that y'all consider this bill strongly, pass this out. I think a comparable bill has already been passed out of the committee in the House. And I just really believe that this would be the right thing to do for our military veterans who, but for the fact that they were not born here, cannot be a Houston police officer or any other. And remember, any agency can say, we would still want to make it a U.S. citizen. This just allows a department that wants to hire someone who's not a U.S. citizen to be able to be a police officer in that department. Thank you very much. I'll answer any questions.
Thank you. Appreciate your testimony. Members, any questions? All right. State your name for the record, please, and give us your testimony.
Good morning, Madam Chairman. Mitch Fuller. I'm the Legislative Director for the Department of Texas Veterans of Foreign Wars of Texas VFW, and we are here to testify in support of Senate Bill 252. I want to thank Senator Alvarado for bringing this bill forward and asking me to come testify. It's our pleasure and honor to do this. We feel that this bill meets the intent of one of the interim charges that the Senate Veterans Affairs took up, facilitate relationships with major corporations and employers, and connect veterans to existing business resources and available state services and access to high-quality jobs in the transition from military service to veteran status. So this bill meets that intent. And Senator Paxton, I want to thank you for your dialogue last week in Senate Higher Ed on another bill. We believe in this, that the key is a transition from military service to veteran status and getting jobs. And we're honored to sit with law enforcement up here, and I want to thank both of them for what they do and all law enforcement for what they do every day. Military experience translates directly into professions such as teaching and law enforcement. This is a great way to do this, and I see this from two different perspectives as well. I'm a former mayor pro tem and city council member in Cedar Park, which is a rapidly growing suburb of Austin. I served on that city council for 7 years. So when you serve on a city council, you have a whole new perspective on what law enforcement does every day. And Senator Birdwell, to your point, I think some of y'all have heard this story. My unit in Iraq, the 56th Brigade Combat Team, when we came home, we had our redeployment ceremony. 3,000 Texans on the field at the old Waco Stadium, Floyd Casey Stadium. We were welcomed home. Governor Perry was there, and there was a federal judge there that gave the oath of citizenship to 30 of our soldiers. So this is a way to get vetted veterans into law enforcement if they so choose. And Senator Birdwell, I appreciate your comments about citizenship, and I'm not sure what happened. It is supposed to be expedited, and we would definitely support that being expedited too. If you're willing to put the uniform on, raise your right hand, and then go into combat in harm's way, you should get a path to citizenship. Thank you.
Thank you for your testimony. Members, any questions? Thank you so much for being here.
Thank you.
Appreciate your service, and I appreciate your testimony today. Is there anyone else wishing to testify on, for, or against Senate Bill 252? Hearing and seeing none, public testimony is now closed. And thank you, Senator Alvarado. Appreciate you bringing forth the bill, and the bill will be left pending, subject to the call of the chair. Thank you. The chair lays out Senate Bill 1678 and recognizes the author, Senator Menendez, to explain the bill.
Thank you, Madam Chair and members. Madam Chair, I do have a committee substitute for Senate Bill 1678.
Thank you. The chair sends up the committee substitute for Senate Bill 1678 and recognizes the author to explain the difference between the bill as filed and the substitute.
Thank you very much, Madam Chair. The committee substitute is simply a legislative council version of the draft that was filed without any substantive changes. So I'll explain both measures as they are the same. It's a very simple bill which would allow Texas package stores, which are more commonly known as liquor stores, to have the ability to do something that many other retailers are allowed to do, which is offer coupons. This bill is a pro-consumer, pro-business bill in the fact that these businesses use the coupons to gain customers and allowing the customers to use coupons to save money on their purchases. Madam Chair and members, there is one invited testimony. Mindy Baker from Total Wine, and I believe TABC is here as a resource, and that's the layout.
All right. Thank you, Senator Menendez. Members, any questions for the author? If not, the chair calls Mindy Baker. All right, thanks for coming, and I appreciate you being here. Please state your name for the record and give us your testimony.
Certainly, thank you. My name is Mindy Baker, and I'm the Director of State and Local Government for Total Wine and More. Madam Chairwoman, thank you for having me, members of the committee. Again, I am representing Total Wine and More. We are a large family-owned retail outlet for wine and spirits. We have about 1,500 employees here in Texas, 38 stores. Texas is, in fact, our largest market across the country. We are in about 27 states. We have about 250 stores across the country, but like I mentioned, Texas is in fact our largest market. Basically, the joke is I'm here for my mother. My mother, still to this day, goes up the street with my neighbor and they clip coupons. My mom is a bargain shopper. She, still, she would be really mad at me if I told her my dress today cost $15. Mindy, don't tell them that. But that's how I was raised. Mom clips coupons, and right now in Texas, we can walk into a store, show my app, and say another retailer gives it for this much. I can offer club coupons or club sales. We can offer different types of sales. The only thing that can't be done in Texas is my mom can't sit with her girlfriend and clip a coupon out of a newspaper. But we can pretty much offer anything else. So that seems a little out of sorts. So we just want to make it so that our customers can clip coupons the old-fashioned way and make sure that they get the best deals possible. We have in our stores here in Texas, just a little bit more background, we do have about 75 employees per store. Most of our stores are about 75% full-time employees, so these are good jobs. We're not trying to take money away from our employees or money away from anybody who's working. We're just trying to make sure that those folks who are working can save some extra cash.
Thank you. Appreciate you being here. Any questions for the witness? All right, thanks for coming.
Thanks.
Chair now opens public testimony and calls Ed Johnson. Is there anyone else wishing to testify on, for, or against Senate Bill 1678? Hearing, seeing none, public testimony is now closed. And thank you, Senator Menendez. The bill will be left pending, subject to the call of the chair. The chair lays out Senate Bill 1512 and recognizes the author, Senator Schwertner, to explain the bill.
Thank you, Madam Chair. This bill regards the appraisals when an eminent domain proceeding occurs. It requires a condemner to pay reasonable attorney's fees if the condemner fails to provide the landowner with 10 years of appraisals for property it seeks to acquire. Currently, a condemner is required by law to disclose at the time of offer to purchase, that the time the offer to purchase is made, any and all appraisal reports produced or acquired by the entity relating to the owner's property and prepared in the 10 years preceding the date of offer. However, there is no enforcement mechanism to ensure these appraisals are supplied. Members, this bill attempts to make information equally available to the landowner and to the entity with the power of eminent domain. I'll be happy to answer any questions.
Thank you, Senator Schwertner. Any questions for the author? Seeing none, the chair now opens public testimony on Senate Bill 1512. Is there anyone wishing to testify on, for, or against Senate Bill 1512? Hearing, seeing none, public testimony is now closed, and the bill will be left pending, subject to the call of the chair. Thank you, Senator Schwertner.
1513.
Yes. The chair now lays out Senate Bill 1513 and recognizes the author, Senator Schwertner, to explain the bill.
Thank you, Madam Chair. This is a bill similar to a bill that passed with 29 votes last session, in the 87th legislative session. This bill requires the inclusion of additional information to the landowner Bill of Rights. There are three parts to the bill. First, the bill provides information on surveys in the landowner Bill of Rights, including the condemner's obligation to pay for actual damages arising from a survey, the landowner's right to seek to negotiate the terms of the survey, and then the condemning entity's right to sue for a court order authorizing the examination or survey if the property owner refuses to consent to the examination or survey. The second part of the bill codifies the two clear offers rule in the landowner's Bill of Rights by providing that an entity who makes an initial offer to acquire property must specify any property they do not seek to acquire through condemnation. This entity must make a separate offer for that separate piece of property. Finally, the bill makes it clear that the landowner bill of rights must be delivered to the landowner with the initial offer instead of 7 days before the final offer is made. This bill essentially updates requirements for content in the landowner bill of rights, which is a document prepared by the Attorney General. Be happy to answer any questions.
Thank you, Senator Schwertner. Members, any questions for the author? All right, seeing none, the chair now opens public testimony on Senate Bill 1513. Is there anyone wishing to testify on, for, or against Senate Bill 1513? Hearing, seeing none, public testimony is now closed, and the bill will be left pending, subject to the call of the chair. Thank you, Senator Schwertner.
Thank you. Appreciate the time.
Chair lays out Senate Bill 2284 and recognizes the author, Senator Middleton, to explain the bill.
Thank you, Chair, members. Today I'm laying out Senate Bill 2284, and the committee substitute to this bill is identical to Senate Bill 655 from last session, which passed the Senate on local and uncontested calendar. And what it does is it will allow our Texas distillers, which are our small businesses that are thriving in this state. There are over 200 now. I've got several in the district like Texas Tail and Raylene Rum, and this would really help them by allowing them to sell not 2 bottles but 4. That's all it does, is it allows our distillers to sell 4 bottles instead of 2 like the law allows now. And 30-day restriction currently in statute will be kept in place. Distillers will also continue to observe the annual 3,500 gallon limit on the sales restriction, and will be required to keep records of their sales as well. Obviously, this is a free market reform bill that will assist our small businesses in being able to sell more of their product and lift some of the unnecessary government rules and regulations. And with that, Chair, I yield for questions and appreciate your time today.
Thank you, Senator Middleton. Are there any questions for the author? Senator Middleton, was there a committee sub? This is not a trick question. Okay. The chair sends up the committee sub for Senate Bill 2284. And you've explained the bill. Thank you.
Yes. Thank you, Chair.
The chair now calls John Evans and Casey Kovacs. Thanks for being here. Appreciate it. And if you would, we'll begin, ma'am, with you. If you would just state your name for the record and give us your testimony. Thank you.
Okay. Thank you for giving us this opportunity. My name is Casey Kovacs, and I'm here today in support of Senate Bill 2284 on behalf of myself and the Texas Distilled Spirits Association. I'm the founder of Hill Country Distillers. My husband and I established our distillery 9 years ago in Comfort, Texas, just 45 minutes northwest of San Antonio off Interstate 10 west. We use Texas native ingredients such as prickly pear cactus, jalapenos, and Texas Valley citrus to produce our unique spirits. Our dream was to have a small craft distillery in Texas about Texas ingredients. 70% of our bottle sales are from visitors over 60 miles away from us. 30% of our bottle sales are to visitors from out of state. We've been fortunate that we've been with a distributor since we opened in 2014, and we currently have 4 products in distribution. But while we have 14 approved labels, Those non-distribution products are very small batch, and we wouldn't be able to supply to the distributors to be in the retail stores. As a small distiller, we pay more for everything because we're dealing with a smaller quantity. Pay more for ingredients, bottles, corks, labels, because I can't buy 100,000 at a time. I'm buying maybe 5,000 or less. Most manufacturers of any kind of product deal with those same kind of economies of scale, but I just wanted to point out that that's what makes it tougher for us small distillers to make a profit. Like many businesses in our state, the pandemic and its aftermath didn't make it easy for distillers. In 2020, our tasting rooms were shut down for months. The bars we supplied were closed, and restaurants were operating at a reduced capacity. We had limited access to customers and fewer opportunities. As a result, we sold like 10% of normal sales, experiencing an overall loss of revenue of 60%. 2021 was a little bit better. Tasting rooms open again, people traveling. However, 2022 was another bad year due to inflation and very hot temperatures. Because of that, in January 2023, my husband and I have made the difficult decision to close our distillery tasting room in Comfort and are working on a partnership with a winery to continue producing spirits. If Senate Bill 2284 had been in place as we tried to recover from the pandemic, we might have been able to keep our tasting room open, might have been able to squeeze out a profit if we'd been able to sell 4 bottles instead of 2. We're thankful to the package stores that they were able to remain open during the pandemic because that was our only sales. So thank you for the opportunity to speak to you and tell my story. I'm happy to answer any questions.
Thank you. Any questions, members? Thanks so much. Please state your name for the record and give us your testimony.
Howdy, I'm John Evans, and I'm here today in support of SB 2284 on behalf of the Texas Distilled Spirits Association and myself. I'm the owner of Wilson Valley Mercantile in Little River, Texas. We opened our tasting room the last week of September 22. I don't know that we were ready, but the bleeding had to stop. We are the first distillery in Bell County. My family has farmed and ranched the land where our distillery sits since 1867. That's 156 years. I'm the 5th generation running the farm and the ranch, and the addition of the distillery is intended to, to make sure the 6th generation has something to call their own. We plan to use the grain that we farm in all our own spirits. Over the last several months, I've spent a fair bit of time thinking about what we are, whether that's seed to glass or grain to glass, farm to field to glass. Most recently, I've come up with seed to sip. I think that reflects what we're doing the best. So we barreled our first barrel of bourbon in November. It will take at least 2 years for that to age. Until it's ready, we're making vodka and white whiskey at the distillery to give something to the people who want to come visit the tasting room. At this point, we don't have a wholesaler, and our product is not in distribution. It probably won't be until the bourbon's ready to distribute. Allowing visitors to buy 4 bottles at my distillery is important while we wait on the aging process. This will provide extra income that will aid in marketing my spirits throughout Texas and hopefully the United States. Without this bill, I can only sell 2 bottles per person every 30 days. So SB 2284 helps the little guy like me who's not yet in distribution in this highly competitive business. Thank you very much for allowing me the opportunity to speak, and I'm happy to answer any questions.
Thank you for your testimony. Members, any questions? All right, thank you. Appreciate y'all being here today.
Thank you.
The chair now opens public testimony and calls Lance Lively, Stephanie Houston, and Ed Johnson. And if there is anyone else wishing to testify on, for, or against, Senate Bill 2284, if you make your way toward the table here. All right. Thanks for being here. And we'll start with you and just work our way across to members. If it's okay, we'll take questions at the end of the panel. after everyone's had a chance to give their testimony. But please state your name for the record. You've got 2 minutes, and then give us your testimony.
Thank you very much. My name is Lance Lively. I'm the Executive Director of the Texas Package Stores Association. I'm here on the bill. We are currently working with our industry partners at the Texas Distilled Spirits Association in another agreement that's separate and apart from this. We hope to have that buttoned up here in the next couple of days. Once we do that, we will move our position to for this bill as it goes from 2 to 4 bottles. Happy to answer any questions. Oh.
Thank you. All right. If you would state your name for the record and give us your testimony, please.
My name is Stephanie Houston, and I'm here in support of SB 2284 as substituted on behalf of the Texas Distilled Spirits Association and also myself. I'm the co-founder of Island Getaway Rum. We're located in Dripping Springs, the wedding capital of Texas and the gateway to the 290 Wine Road. This is a major thoroughfare for tourism in the state of Texas. When a visitor comes to a distillery, they're able to purchase 2 bottles per person per 30 days. Our distillery, for example, offers 5 different expressions. This bill will allow distilleries to sell an additional 2 bottles to our visitors, which is important for several reasons. First, it's important just to a distillery's bottom line, especially if they're not in a distribution channel. Right now, there's just no other way to actually sell their products. Next, it's also important for a distillery business as a whole, as visitors primarily visit on the weekend, and this means sales are primarily captured on Saturdays. This is also important to distilleries that are distributed, as it helps us introduce our products to the consumer and hopefully drive those sales home when they go home to their local package stores. I believe that 2 additional bottles can help the distillery's bottom line. It can help with our ability to compete against some of the larger brands, and is also a mindful approach to our friends at the retail package stores. I appreciate your time today, and am happy to answer any questions.
Thank you. Appreciate you being here. Please state your name for the record and give us your testimony.
My name is Ed Johnson. I'm here representing myself and the Giddings Economic Development Board. So when I retired from my election job, I moved to ranching and ended up in the town of Giddings on the Economic Development Board. And we have a small brewery in Giddings. I brought a little sample bottle. Now, I didn't know if alcohol was legal or not in the Senate chamber, so this is actually tea in here. This was an old bottle that I had.
Open carry, right?
And put some in there. I would have brought y'all some samples, but I'd already exceeded my limit this month, so I couldn't get any more to bring y'all up here. So this is a great bill. You know, if I had this, I could. Our distillery actually has 8 different product lines, and I could have brought y'all some samples up here for you to see for the great bill that y'all are passing. These little distilleries in small communities have become a real community center hub. They have the community takes great pride in these. It's a higher end retail area, so it's a fun activity to go. Most of the time, our distillery has a street band or something on the weekends. It's a great community effort, and this helps keep them in business by able to sell a little more of their product on the market, as you've heard from other testimonies. So I hope you pass this bill, and when you get it done, next time I come up, maybe I can bring more bottles with me.
All right, thank you. Members, are there any questions for the witnesses? All right, thank you so much for being here. Appreciate it very much. Is there anyone else wishing to testify on, for, or against Senate Bill 2284? Hearing and seeing none, public testimony is now closed. And the bill will be left pending the committee substitute for 2284, right? Thank you. And the bill will be left pending, subject to the call of the chair. All right, the chair now lays out Senate Bill 1893 and recognizes the author, Senator Birdwell, to explain the bill.
Thank you, Madam Chair. Members, I ask your deference to a little bit of a lengthy layout as it relates to the bill. On December 7th, 2022, Governor Abbott directed state agency leaders to immediately ban its officers and employees from downloading or using TikTok, a social media application, on any government-issued devices, including cell phones, laptops, tablets, desktop computers, and other devices capable of internet connectivity. The Texas Department of Public Safety and the Texas Department of Information Resources have developed a model plan for other state agencies to utilize in execution of carrying out the governor's executive order. TikTok became wildly popular worldwide during the COVID-19 pandemic, and the social media application was the most downloaded app in 2021 and 2022, and is currently credited to be the most downloaded app of all time with over 2 billion downloads globally. It has been most recently reported that TikTok has more than 150 million users in the United States alone. For those who may not know, TikTok is a social media platform that allows users to create, watch, and share short videos shot from mobile devices. TikTok, while having headquarters in Singapore and Los Angeles, is a subsidiary company of ByteDance, a Chinese internet technology company that is headquartered in Beijing. ByteDance has developed and services the Chinese-specific counterpart of TikTok known as Douyin. So why does TikTok, a social media platform that states our mission is to inspire creativity and bring joy, pose such a threat to our state security and that it merits a ban for Texas governmental entities? The People's Republic of China National Intelligence Law of 2017 forms the baseline of the modern data collection regime and compels all PRC firms and entities to support, assist, and cooperate with the PRC intelligence services, creating a legal obligation for those entities to turn over data collected abroad and domestically to the PRC. Article 7 of this law states, any organization or citizen shall support, assist, and cooperate with the state intelligence work in accordance with the National Intelligence Law and keep the secrets of the national intelligence work from becoming known to the public. The law further establishes a system of incentives for compliance and penalties for noncompliance, stating that the PRC commends and rewards individuals and organizations that have made significant contributions to national intelligence work. And furthermore, if an individual obstructs the intelligence work according to law, that person shall be dismissed, investigated, and/or detained. According to TikTok's own privacy policy that was updated on January 1st of this year under what information we collect, quote, we may collect information from and about you, including information that you provide, information from other sources, and automatically collected information. Information that you provide is information related to an individual's profile, name, email, username, passwords, phone numbers, and additionally, it's information from your usage on the platform, such as video uploads, your messages that you send to other users. If you as an individual give TikTok permission to your contacts, the app will collect your public profile information as well as the names and profiles of your social network contacts. Information from other sources, including information from other platforms such as Facebook, Instagram, Twitter, Google, to name a few. This ranges from advertisement data from those platforms, mobile usage identifiers, and usage activities on those platforms. In the privacy policy under the section of automatically collected information, it states, we automatically collect certain information from you when you use the platform, including internet or other network activity information such as your IP address, geolocation, related data, unique device identifiers, browsing and search history, and cookies. Members, I'm going to provide you some additional direct quotes from this section of the privacy policy. We collect certain information about the device you use to access the platform, such as your IP address, user agent, mobile carrier, time zone settings, identifiers for advertising purposes, model of your device, the device system, network type, device IDs, your screen resolution, and operating system, app and file names and types, keystroke patterns or rhythms, battery state, audio settings, and connected audio devices. We automatically assign you a device ID and a user ID where you log in multiple devices. We will also be able to use information such as your device ID, user ID to identify your activity across devices. We may also associate you with information collected from devices other than those you use to log into the platform. We collect information about your approximate location, including location information based on your SIM card and/or IP address. With your permission, we may also collect precise location data such as your GPS information. We may collect information about the videos, images, and audio that are part of your user content, such as identifying the objects and scenery that appear, the existence and location within an image of face and body features and attributes, the nature of the audio, and the text of the words spoken in your user content. We may collect biometric identifiers and biometric information as defined under U.S. laws, such as face prints and voice prints from your user content. Under the Data and Security Retention section of TikTok's privacy policy, it states, TikTok may transmit your data to its servers and data centers outside of the United States for storage and/or processing. Other entities with whom TikTok may share your data as described herein may be located outside of the United States, and we retain information for as long as necessary to provide the platform and for the other purposes set out in this privacy policy. TikTok claims that sensitive user information is stored in data centers in the U.S. and Singapore. On June 30th of last year, TikTok's CEO submitted a response letter to the Senate Commerce Committee revealing Project Texas, which is TikTok's attempt to provide more substantive safeguards to user data privacy information by storing all U.S. user information in the Oracle Cloud here in Texas. On March 23rd, though, Mr. Chu testified before the House Energy and Commerce Committee and provided unclear answers regarding access to TikTok U.S. user data. His testimony indicated that Project Texas is a major undertaking that requires the expertise from many employees and could not specify if the employees working on the project had ties to the Chinese Communist Party. Senate Bill 1893 requires Texas governmental entities to adopt a policy prohibiting the installation or use of a prohibited application, specifically TikTok or any other application owned or developed by ByteDance Limited, on any device owned or leased by a Texas governmental entity. This bill defines government entities as departments, commissions, boards, offices, or agencies under the legislative, executive, or judicial branch, and this bill also extends the prohibition to public institutions of higher education and political subdivisions, including in municipalities, counties, special purpose districts, school districts, or any other geopolitical subdivision. This bill does provide exceptions for law enforcement entities so that social media platforms have become a tool for various degrees of criminal activity. The cartels have begun using apps like TikTok to recruit young Texans to aid them in their illegal activity. So it allows for law enforcement to use that application for the purposes of monitoring criminal activity. Senate Bill 1893 will allow the governor to prohibit additional applications that pose a similar security risk by executive order. Madam Chair, I do have a committee substitute.
Chair sends up the committee substitute for Senate Bill 1893 and recognizes the author to explain the difference between the bill as filed and the substitute.
Thank you, Madam Chair. The committee substitute defines a security risk as an application service provider that may be required to provide confidential or private personal information to a foreign government without due process or similar legal protections. I just want to reiterate that this bill only applies to governmental entity devices. Members, it is evident that TikTok poses a significant threat to the privacy of citizens of the state of Texas, our state security, and potentially a national security question, and quite frankly, our individual privacy and security. Members, I also have the Deputy Director of Cybersecurity Coordination from DIR is here to assist if any of their technical questions related to the bill. With that, I ask your favorable consideration, members.
Thank you, Senator Birdwell. Appreciate that. Members, any questions for the author? All right.
Not unless any of the members do.
Is there anyone wishing to testify on, well, first of all, Chair opens public testimony. And is there anyone wishing to testify on, for, or against the committee sub for Senate Bill 1893? Seeing none, public testimony is now closed. And the committee sub for Senate Bill 1893 will be left pending, subject to the call of the chair. Chair lays out Senate Bill 1097 and recognizes the author, Senator Parker, to explain the bill.
Thank you, Madam Chair and members. Appreciate the opportunity to come before you today with Senate Bill 1097, and I do have a committee substitute.
Chair sends up the committee substitute for Senate Bill 1097 and recognizes the author, Senator Parker, to explain the difference between the substitute and the bill as filed.
The committee substitute for 1097 seeks to provide Wise County Health System a legislative waiver of immunity, which is necessary to facilitate their sale to Medical City. Currently, the law is unclear whether the authority as a political subdivision can indemnify the purchaser of the authority's assets for liabilities that predate the sale, and whether or not a sovereign immunity would block any claim by a purchaser to recover from the authority for liabilities of the authority which predate the sale. Resolution of the issue is necessary because no reputable purchaser would agree to be exposed to a known or unknown claim that may predate their potential ownership. Members, this is a local bill that would specifically apply to Wise County and is intended to help improve the delivery of health care services in the area. Appreciate the opportunity to come before everyone this morning and lay out the bill.
Thank you, Senator Parker. Members, are there any questions for the author? If not, the chair opens public testimony on Senate Bill 1097 by Senator Parker and calls Jason Wren, Mary Elizabeth Castle, and Gregory Porter. And if there is anyone else wishing to testify on, for, or against, if you would begin making your way down. All right, we're going to get you started. Please state your name for the record and give us your testimony, please.
Hello, my name is Jason Wren. I'm the president and CEO of the Decatur Hospital Authority, which does business as Wise Health System in Wise County. I want to thank Senator Parker for sponsoring this legislation for us and for the committee for considering it. I'll briefly explain why Senate Bill 1097 is so important to our hospital and our community and surrounding communities. The Decatur Hospital Authority is a municipal hospital authority and political subdivision established pursuant to Chapter 262 of the Texas Health and Safety Code and by ordinance of the City of Decatur. The authority owns and operates a 150 licensed bed acute care hospital in Decatur, Wise County, and multiple affiliated ancillary facilities. Wise County is beginning to experience significant growth, which is expected to increase significantly during the next decade. There are new and changing financial realities of the healthcare system as a whole, which include increasing costs and declining reimbursements. Approximately 600 small community hospitals nationally are at risk of closure. The authority is not immune to these financial realities, which are making it increasingly difficult for independent hospital systems like the authority to remain an independent hospital operator. These challenges are increasing regardless of location, but are especially true in markets like Wise County with the significant growth we are experiencing. To ensure access to capital and resources that will help keep healthcare local, ensure continued jobs for healthcare workers, and grow and enhance the services for the authority's patients, the authority is seeking to strategically align with a larger system. The authority's board of directors, which is made up of local community leaders, has determined this acquisition by a national healthcare facility operator is the best way to ensure continued access to care and the broad array of services for Wise County residents. Currently, the law is unclear whether the authority as a political subdivision can indemnify the purchaser of the authority's assets for liabilities that predate the sale and whether or not sovereign immunity would block any claim by a purchaser to recover from the authority for liabilities of the authority which predate the sale. This is the important point with this bill. The bill seeks a clear waiver to allow the authority to indemnify the purchaser for those matters that may have happened before closing while on the authority's watch. This is only fair and is something that any purchaser of a business would expect. Resolution of this issue is necessary because no reputable purchaser would agree to be exposed to a known or unknown claim that may predate their potential ownership. Current law requires that there must be a clear and unambiguous statutory waiver of sovereign immunity by the political subdivision, and this bill would provide that waiver. I'll close by pointing out that this bill is bracketed so that it will only impact the Decatur Hospital Authority, would not impact other political subdivisions. Obtaining this waiver is necessary to complete our transaction. Wise Health System is the largest employer in Wise County. Completing this will preserve jobs at the local level. It will preserve health care at the local level, will allow Wise County citizens to continue to receive care close to home, and maintain more geographically accessible health care for other rural communities to the west and north of Decatur who utilize our hospital for certain services. I'll close by saying thank you again for your consideration of this bill, and I'm available to answer any questions.
Thank you. I appreciate you being here. Members, any questions? All right, thanks. Appreciate it.
Thank you for the great testimony.
Is there anyone else wishing to testify on, for, or against the committee sub for Senate Bill 1097? Seeing none, public testimony is now closed, and the bill will be left pending subject to the call of the chair. Chair now lays out Senate Bill 1375 and recognizes Senator Parker, the author, to explain the bill.
Thank you, Madam Chair and members. Appreciate the opportunity to come before you today with Senate Bill 1375. Currently, a distiller can only participate in a festival when a civic or local festival organizer is granted a daily temporary mixed beverage permit from TABC. Under this system, the festival organizer then must purchase the distilled spirits from the holder of a local distributor's permit. If a distiller wants to participate in a festival, the distiller must then purchase its own product from the venue or the festival organizer at cost plus the retail markup. The distiller then often has to hire a promotional company to serve the product at the event. Small distilleries cannot afford to pay for a booth at the event and then, on top of that, repurchase their own alcohol at a retail price to then be able to serve at the event. In 2009, Senator Nelson and Representative Guerin passed a bill which created a winery festival permit. And according to the Texas Wine and Grape Growers Association, participating in festivals has made an immense difference for small wineries in Texas. Senate Bill 1375 will give Texas distillers a similar means to showcase their product by providing tastings and/or samples. Simply put, Senate Bill 1375 will allow a distiller to bring his or her own product to the event, cutting down on the cost of participating. Thank you, Madam Chair and members, for the opportunity to lay out the bill this morning.
Thank you, Senator Parker. Members, any questions for the author? All right. If not, we'll move on to testimony. Chair calls Stephanie Houston. Getting a lot of steps in today, right?
Getting them all.
Welcome, and please state your name for the record and then give us your testimony.
Thank you. My name is Stephanie Houston, and I'm here today testifying in support of SB 1375 on behalf of the Texas Distilled Spirits Association and myself. To remind you, I'm the president and co-founder of Island Getaway Rum in Dripping Springs, Texas. And I'm also one of a small group of Hispanic female distillery owners in the United States. I started my rum distillery in 2016, and every day since, we've been spending all of our time building the brand. Prior to that, I spent 25 years in marketing. Marketing is a very, very expensive endeavor. Marketing opportunities are critical to the success of an emerging brand in Texas. This is because once the brand can be recognized, that can translate into long-term sales at a lot of our Texas stores. SB 1375 allows us to bring our own samples and our own products in front of hundreds, if not thousands, of potential customers. One particular instance of an event that we did, we were able to bring our samples to 16,000 samplers. That was a huge marketing opportunity, and 7 or 8 months later, we're still seeing the benefits of that. Currently, though, in order to participate in those festivals, we have to repurchase our products, and we're repurchasing them at the retail price. So recently, again, we did another event in Dallas, and then at the end, we got a bill for $3,000 to buy our own spirits back. After that, anything that was unused, we didn't get to take home. So we had to pay it and leave it. A lot of times, those costs just are not feasible for small distilleries. And so this is helpful for small distilleries that don't also have their products in distribution. So SB 1375 will allow our distiller to bring our own products, and we think that's a great, great benefit to all business. I'm happy to answer any questions.
Thank you. Members, any questions? Thank you for being here.
Thank you.
Chair now opens public testimony and calls Ed Johnson. All right, please state your name for the record and give us your testimony.
Yeah, Ed Johnson. I'm representing the Giddings Economic Development Board, and we are for SB 1375. Giddings is just down the road on Highway 290 for y'all that head south when you leave here at the Capitol. Probably drive through. But right next door is Round Top. And, you know, they have this huge antique market where I think it's like 100,000 people go to it. And then they have this huge 4th of July thing. But our little, you know, brewery or distillery doesn't get to go and put samples out just for, you heard the testimony before on the cost factor. So this would allow us to advertise, to let people in the community know that, you know, this is a activity event, a venue that they could go and see and do. I talked to the owners of our little brewery distributor, and they said that they thought the legislation here was probably a really special event, and they would be able to set up a tasting room in the back hall if y'all managed to get this bill passed.
Thank you for your testimony. Is there anyone, members, any questions? Sorry about that. All right. Is there anyone else wishing to testify on, for, or against Senate Bill 1375? Seeing none, public testimony is now closed, and the bill will be left pending subject to the call of the chair. Chair lays out Senate Bill 926 and recognizes Senator Parker, the author, to explain the bill.
Thank you, Madam Chair and members. Appreciate the opportunity to come before you this morning with Senate Bill 926. Senate Bill 926 seeks to reinstate the ability of the Texas Motor Speedway to apply for temporary beer and wine permits and allow patrons to bring in alcohol in their personal coolers. As many of you know, during the 79th regular session back in 2005, Senate Bill 1331 granted the Texas Alcoholic Beverage Commission, TABC, the ability to issue up to 4 temporary wine and beer retailers permits per year to the Texas Motor Speedway in Denton County. This legislation was critical for the Speedway, which hosts major NASCAR races and other significant events in the community. The Speedway holds a mixed beverage permit to sell alcohol, but prior to 2005, they were unable to sell alcohol in the general seating and common areas. However, during the 86th regular session in 2019, the TABC was undergoing sunset review. This process resulted in the consolidation of many alcohol permits, but unfortunately, the specific language granting temporary permits for the Texas Motor Speedway was not included in another section of code leading to its repeal. Senate Bill 926 will put the original statute back into law, allowing the Texas Motor Speedway to apply for the temporary 4-day beer and wine permits and allow patrons to bring in alcohol in their personal coolers. This is a critical step in ensuring that the Texas Motor Speedway can continue to thrive, and I ask for your support of Senate Bill 926.
Thank you, Senator Parker. Members, are there any questions for the author? Seeing none, the chair opens public testimony on Senate Bill 926. Is there anyone wishing to testify on, for, or against Senate Bill 926? Seeing none, public testimony is now closed, and the bill will be left pending subject to the call of the chair. Thank you, Senator Parker.
Thank you.
And I'm going to pass the gavel to Senator Birdwell. So I lay out a couple of bills.
I messed that up.
Chair lays out Senate Bill 417 and recognizes the author, Senator Paxton, to explain the bill.
Thank you, Mr. Chairman. Thank you, members. Protecting children from harm is a primary duty that parents have, and we also have a vested interest in doing that as a state. Yet in this day and age, the devices that children use on a daily basis have readily available hardcore pornographic content, videos, and pictures that harm the minds of these minors. Texas law already prohibits exposing a minor to pornography in Section 43.24 of the Texas Penal Code relating to sale, distribution, or display of harmful material to a minor. According to the National Center on Child Exploitation, pornography is shown to be biologically addictive. Furthermore, research shows that adolescents are even more susceptible than adults to addictions, and there are developmental effects on the brain. Exposure to explicit content in childhood is linked to an increase in the demand for child pornography, child exploitation, human trafficking, and prostitution. Children who use pornography are more prone to engage in risky sexual behaviors and are at risk of sexual victimization, which is also linked to mental health disorders. Self-generated imagery now accounts for 1/3 of web pages featuring child pornography. Sexualization through devices is creating more demand, access, and content creation from minors themselves. Children's development is harmed when viewing, as a result of viewing content from mainstream pornography websites that shows sexual violence, incest, physical aggression, sexual assault, non-consent, and teens engaged or being victimized. In 2021, Utah passed device filter for minors legislation, and currently 8 states have introduced legislation in kind to protect minors from the dangers of pornography. And these states include Florida, South Carolina, Maryland, Tennessee, Iowa, Idaho, and Montana. Members, virtually all devices already have filters to filter out this type of harmful content, but the filter is preset to off when the device is activated. Senate Bill 417 simply requires manufacturers to change the default upon activation from off to on, so that is the default. It will be technically easier for parents to locate this setting by placing it during the activation sequence. And the decision to use the filtering, of course, remains the choice and at the determination of the parent or guardian. This bill simply puts the onus on the manufacturer to activate the filter upon activation of the device in Texas to protect more minors from explicit material on the internet. And Mr. Chairman, I do have a committee sub.
Senator Paxton sends up committee substitute, and the chair recognizes Senator Paxton to explain the difference.
Thank you, Mr. Chairman. The committee substitute for Senate Bill 417 defines some of the terms, such as adult and minor users. It clarifies that the applicability is for manufacturers, and it removes liability for a non-parent violator. Thank you, Mr. Chairman and members, for your consideration of Senate Bill 417.
Okay. Members, questions of the author? If not, we'll move to public testimony. Chair calls Decia Wiggins, Deborah Simmons, and Joseph Haas. And then on deck, Deborah Berry, Andrea Sparks, and Luke Montgomery. So Decia Wiggins, Deborah Simmons, and Joseph Haas. The three of y'all would join us. And then on deck, in the next panel, Deborah Berry, Andrea Sparks, and Luke Montgomery. Each of you has 3 minutes. And Decia, am I saying that correctly?
It's Deasia.
Okay. Thank you, ma'am. If y'all would, pull your microphone to you. You have 3 minutes. You're recognized, Ms. Wiggins.
Good morning, Chairman and honorable members of the State Affairs Committee. My name is Deasia Wiggins, and I moved from Washington, D.C. to Houston in 2020, where I currently attend Texas Southern University. I am here to support SB 417, A common sense bill that says when cell phones and tablets are activated in Texas, filters blocking hardcore pornography should be on, not off like it is now. I learned about this bill from the National Center on Sexual Exploitation, a group based in Washington, D.C. I worked with NCOSE in 2019. One of the realities NCOSE talks about, and I have lived, is that many forms of sexual exploitation are connected to each other. So, for example, the constant exposure kids are getting to very violent pornography through phones has led to an increase in sexual violence that kids are committing against each other. Nurses in emergency rooms across the country are reporting this. Everyone has these phones, but not everyone has parents to put filters on them or to limit their use of the devices. My adopted mother died when I was 11 years old. After that, I lived with many foster families and group homes where there was no relation. Due to the lack of supervision, I explored hardcore pornography, which created unrealistic ideas. I tried to imitate those scenes, which put me in very dangerous situations. Plenty of kids I knew and lived with access hardcore pornography at a young age. This material is very violent and very degrading. I also believe that there's a huge link between pornography and bullying. Adults have no idea what we are seeing, and kids act out on other kids as a result. I have friends who have been choked, slapped, spanked, and raped because that's what people using pornography think sex is about. This is also happening to boys, not just girls. The situation could be quickly improved if it was harder to access pornography on our devices, automatically as SB 417 would require. Don't tell me it is hard for these multi-zillion-dollar companies to figure it out. That's a joke. The current situation is creating real danger and pain. I sincerely hope you vote for the kids in this case, not the big tech lobbyists paid to distract you from real people like me. Thank you.
All right. Thank you. Deborah Simmons, you're recognized, and then Joseph after that, and then members after the panel's complete, then we'll open up the questions for the entire panel.
I'm Deborah Simmons, and I am for Senate Bill 417 to require filters on devices activated in Texas. I spent 10 years in the IT industry before starting a family. My work included technical support, systems engineering, technical sales, consulting, and manufacturing development engineering for Unix-based products. For 18 months in the 90s, I was the software load engineer in the manufacturing facility for enterprise servers, responsible for managing the imaging of the operating system, software products, and software updates for every product shipped out of the Northern California facility. Every 2 months, software bits were delivered to the factory for every installation server so that the latest and best product was delivered to customers. Often, product bundles were customized for specific customers and destinations. Customers were confident that their brand new Unix-based enterprise servers had the most up-to-date products installed. I was also certified as an ISO auditor to ensure that products were built and delivered through a quality-controlled process from the factory and through distribution channels. I am confident that now, 25 years later, installing devices with activated filters is not difficult and can be done seamlessly and flawlessly. Texas has a compelling interest to protect children, and this legislation will do just that. By toggling explicit content off by default, Texas citizens will be assured that their devices are safe from unexpected inappropriate content accessible through operating systems and manufacturer applications. Adults desiring access to such content can easily toggle the explicit content features back on. We know that pornographic content is damaging to the brain and future success of young Texans. Please protect Texas children by providing this valuable protective feature to Texas families by passing Senate Bill 417. Thank you.
Right. Thank you. Thank you, ma'am. Mr. Haas, you're recognized.
Good morning. My name is Joe Haas. I live in Dallas, Texas, and I'm speaking on my own behalf. I'm a software engineer or a computer programmer. I've been programming for over 10 years. I have been a team lead for other programmers, as well as a manager and coach for other programmers. I am in favor of this entirely common sense bill, SB 417, and I'm here to speak about its technical feasibility. I call it common sense because there are already some filters existing on these major devices. They're just hard to set up. The primary components necessary to turn them on already exist. The filters themselves, the ability to adjust the filters, the ability for a device to detect what state it is in, and an activation sequence during which the setting would be applied. Phones already adjust their time based on location. Similarly, phones could detect the location during the activation, and if that's occurring in Texas, the filter would be turned on. Users could then override the setting if they so chose. I can't speak for all phones and all of their filters, but I'd like to illustrate my point of how easy this is with one particular filter. On Apple devices, many clicks deep into the settings of the Apple device, a user can set a filter to the option of limit adult content. To set this particular filter correctly in the manner proposed by this bill would be absolutely trivial compared to the other features that these manufacturers do on a regular basis. Having worked on numerous projects and with numerous other engineers, I would estimate potentially to do this particular change for this particular filter could take as little as a single day of an engineer working on it. Could take a little longer, but it wouldn't take very long. And then, of course, once the adjustments are done to the code, it would be pushed out in an update to all the relevant devices. That's it. Thank you.
Thank you, Mr. Haas. Members, questions of the panel. Senator Paxton, you're recognized.
I just want to thank all of you for being here and bringing your expertise and experience to the relevance of this bill. And I just wanted to ask just a basic clarifying question. Is this a software or a hardware fix?
It is a software fix.
So this doesn't require any manufacturer to do anything special other than a software update, which we have seen. Of course, these happen on a periodic basis anyway. And do any of you see that as a burdensome sort of process to enact?
To apply filters that already exist? No, that wouldn't be very burdensome, no.
Thank you very much.
All right. Members, other questions for the panel? All right. Thank you all for joining us today. Thank you.
Thank you.
Chair calls Deborah Berry, Andrea Sparks, Luke Montgomery, and then on deck in the following panel, Dawn Wibble, Jack Raymond, and Sean Callender. So, all right. Deborah, we'll begin with you. If each of you would state your name, whom you represent, you have 3 minutes. Deborah, you're recognized.
Hi, my name is Deborah Berry. I'm here as a parent and an individual. In 2016, if you had told me I would be fighting the fight of my life to save my daughter from online sexual predators, I would have said to you, no way, not me, because I am a stay-at-home mom. I did talk to my children, I must try not to cry, about the dangers of the internet. But as it turns out, it was me and it was my daughter. Upon a routine check of her technology, I discovered through some screenshots she had taken dialogue between her and strangers. The language was so explicitly charged, sexually charged, I had no idea my daughter even knew those words. My daughter, I found it at 12 years old. She was 10 years old when this started. This only indicated the tip of the iceberg. Upon further investigation of her laptop, which I gave her, by the way, I discovered endless visits to porn sites, specifically Pornhub, as well as videos, pictures, adult dating sites. Not only was she viewing material, she was creating and distributing material, photos and videos of herself. This child was 10. By the time she was 15 years old, the biggest dream she could dream for herself was to go to LA and work in the adult film star, which thank God she did not. What does internet pornography do to a child? It is nothing short of a thief. It is the lowest of the low, preying on the vulnerabilities of a young, naive child and those who love her. That is the crime. Robbing my child of her innocence because she can never, ever unsee what she has seen. Robbing her of her security because she can never take back the pictures or videos that she posted, and she can never guarantee that they won't resurface either. Robbing me as a parent of precious time with her because she was unreachable and I sent her away to keep her safe. Robbing me of the opportunity to teach her about love, sex, and the morals that I believe are a critical part of a healthy, happy, productive life. Access to internet pornography tainted her mind and forever changed the innocent child that she was. Again, this is my 10-year-old.
Thank you, Deborah.
This is what I now know. My daughter has been digitally sex trafficked. It does not matter how many protections I built around my children. It does not matter what neighborhood my family lived in. It doesn't matter whether they attended a private or a public school. What matters is that my children have technology in their hands and they're living in a virtual Wild West. The curiosity of a child is not wrong. It's natural. What is wrong is when tech companies knowingly allow kids to access things that harm them and then do nothing about it. We have an entire generation of young kids who are accessing porn to the point they don't even think it's an issue, much less a problem. I don't say this lightly. Our children are on a runaway tech train headed straight for hell. I know what it means to have a child on that train, to be overwhelmed, exhausted, and outflanked by the technology that grips her. I know what it means to be a parent desperate for answers and looking for solutions. I know what it means to have dreams shatter for your children and your heart broken because you can't recognize the place that you find yourself or your family in, and you have no idea what to do about it. From the bottom of my heart, I would not wish such a moment on anybody. So let me ask you, why would anybody allow big tech to help predators steal the soul of my child, or any child for that fact? To do nothing is to be complicit, and to me it's not acceptable.
Thank you, Deborah. Thank you. Mr. Montgomery, you're recognized.
Thank you so much for having me. I'd like to take this time to show my support for Bill 417. I'm 21 years old. I'm currently a student at Dallas Baptist University. When I was in third grade, I was exposed to pornography for the first time. A classmate of mine who had an iPhone showed me an image in the bathroom after class. That day opened a world to harmful online content for me that would plague me for multiple years to come. Early on in fourth grade, I remember staying in from recess and sneaking into empty classrooms to access images online on the back computers. As I got older, I was entrusted with the school iPad and MacBook, where I quickly found access to similar content. And as is the story of so many others, what I viewed continued to get worse until I continued down a path that I would never imagined when I began. I got to my middle and high school years, and I was suspended multiple times for using my devices. Each time, I continued to look for new ways to circumvent whatever system was in place. I wrestled with the effects of pornography and tried to keep them all to myself, but like most things, they leaked into other parts of my life. The most prominent effect that I had was anger. I was angry all the time. I was quick to snap at my friends, my parents, and my siblings, and I always felt that I had to defend myself even at the slightest accusation. I never ceased from having something to prove, and I was determined to accomplish it no matter what the cost was. My aggression came out on the basketball court. I was finally told that I couldn't play anymore due to my dirty plays. It came out in my everyday conversations with my friends that I didn't even know about until years later when they approached me and were still wounded by some of the things that I said. Most importantly, though, it was directed towards my parents. I grew up hating my parents for constantly trying to protect me from what I didn't even realize I needed protection from. See, my story isn't just one of my struggles, but it's also one of my mom and dad's battle for my identity. Parents have the biggest responsibility of protecting their children, and they should have easy access to the tools to do so. There's no way that I would be the man that I am today without the constant battle that my parents fought for over 8 years before I was ready to get help. In my junior year of high school, I realized that I could not continue with what I was doing, and I was in and out of counseling, but ultimately I overcame my addiction because of the amazing community that I have and my faith in my Savior, Jesus Christ. The time for parents to start having the dreaded sex and porn talks with their children is being pushed earlier and earlier. If they choose not to, they run the risk of their kids hearing it or seeing it from somewhere else, and it may be too late. It is paramount that they have easy access to the tools to do this, to protect kids early in order to safeguard them for the long haul. Thank you.
Thank you, Luke. Andrea, you're recognized.
Thank you, Chairman, members, and Senator Paxton for filing this very, very important bill. I don't know how to follow these courageous witnesses. I'm so glad y'all came today. I'm here today representing Buckner International and testifying for the bill. Buckner serves children, family, and seniors across Texas, but I'm also here today as the former and first director of the governor's Child Sex Trafficking Prevention Team, which was created by the legislature in 2015 and where I served till December of 2021, and as the former director of the Texas Regional Office of the National Center for Missing and Exploited Children, or NCMEC. NCMEC serves as the nation's centralized reporting system for suspected child sexual exploitation and partners with federal, state, and local law enforcement agencies on cases of missing and exploited children. And lastly, but more importantly, I'm here as a lifelong child advocate and a concerned mother, aunt, and maybe future grandmother. As the internet and social media and online messaging apps, gaming, entertainment, online education have exponentially grown in the last 10, 15 years, so has, unfortunately, the sexual victimization of children via these means. No doubt that technology is an overall force for good, for knowledge, for efficiency, but one of the most unfortunate side effects is the sexual exploitation of our children. This includes the intentional exposure of children to pornography and other illicit material. It includes online enticement. It includes sextortion, grooming, trafficking. All of these online harms reached their fever pitch just recently when schools went online, kids went online, predators, of course, went online. NCMEC reported that between 2018 and 2022, there was a 567% increase in online enticement. And unfortunately, like the pandemic is over, this epidemic is not over. And NCMEC is reporting that the rise in this continues to grow to inconceivable levels that we never thought would happen. Witnesses have mentioned self-produced imagery. This is a growing concern, so much so that NCMEC has a new service called Take It Down, where they help children take their own images off of the internet where they can and where electronic service providers are willing to help them with that. Senate Bill 417 is a simple solution that makes it easy for parents to protect their children. It would not require smartphones or tablet manufacturers to do anything different than they are already doing in many other contexts. It requires them to set a filter that automatically filters out explicit material on a smartphone, to toggle it on so parents can toggle it off when they want to. These parental controls are already present, but as witnesses have said, they're very difficult to find, to figure out. Might take you many Google searches to figure out how to do it. And unfortunately, some parents just aren't that tech savvy, and some parents, unfortunately, won't care. But that doesn't mean that their children don't deserve to be protected from this harmful pornography and other illicit images, which are, as witnesses said, very damaging. So I just want to mention, I can't believe I did this whole thing without glasses.
Andrea, would you bring
I'm going to wrap up,
closing
yes.
thought? So,
That's okay.
yes, ma'am.
Okay, so this is a widespread problem that can't just be fixed with the snap of our finger or even with just this bill, but it is a step in the right direction. This bill is a step in the right direction, and I urge y'all to support it, and I'll answer any questions you have.
Okay, thank you. Members, questions of the panel. Senator Paxton.
I just want to thank all of you for being here today and taking time. Deborah, as you were telling your story, so I'm a mother, grandmother. I was a school counselor, teacher, worked with parents, worked with kids. And first of all, I am so sorry for the heartbreaking experience that you and your daughter have had to walk through. I'm thankful for your daughter that she has someone to be with her and to engage in this in a proactive way. But I wonder, as you have been dealing with this issue, have you met other parents who are dealing with the same thing?
Yes. As a result of this experience, I did end up writing a book that I have done a lot of speaking engagements on. I tell this story and I talk about the knowledge I gained about technology and try to make awareness and education around those things. So I've spoken to lots of adults. Rarely is there not someone that doesn't come up to me and tell me, you got to keep talking and thank you, and we just have no idea, so on and so forth.
Thank you. In your experience, is this a rare problem or a common problem?
This is an overwhelming problem. I called it the tech train from hell. I'm telling y'all, we are headed in a place that is terrifying. Whether you have children of your own, young children that you're raising and you're thinking, oh no, this is terrible, it's very difficult, or you've already raised children and you're thinking, I'm so glad I've raised my children. It affects us all. We have an entire generation headed straight for us that have been doing nothing but watching porn, whether by accident or on purpose. I have a 28-year-old daughter as well. The dating apps, part of the deal is you just show your body parts. That's what people do. That's what these kids think they're supposed to do, is take pictures of their body parts and share them with each other, because that's the normal rituals.
Members, just to be very clear, these filters already exist. They're software. They don't require manufacturing changes. The filter already exists. And there's already a default setting for the filter, which is off. I can't think of any reason that the default should be anything other than on. Let's override the other way and let's default to protection. Thank you.
May I add something? Parents are asking me constantly for the silver bullet, which of course I don't have the answer to how to prevent this stuff. They are desperate. Mm-hmm. They don't know what to do.
We should make it easy for parents, not hard for parents. The easiest way we can do it. Thank you.
Yeah. Thank you. Members, any other questions for the panel? All right. Thank you all for joining us. Thanks. Thank you for joining us. Chair calls Dawn Wibble, Jack Raymond, and Sean Callender, and then on deck. Right, beginning the next panel.
I'm Dawn Weibel.
Hold on.
Oh.
And then on deck, after this panel, Jamie Carruthers, Denise Siebert, and Servando Esparza are on deck. So with that, Dawn, you're recognized. Each of you has 3 minutes. Please state your name, whom you represent.
Okay, thank you. I'm Dawn Weibel, and I'm in support of the bill and for myself and for my organization, Talk More, Tech Less. Good morning. Thank you for having us here today. As an online safety advocate and digital wellness educator and the founder of Talk More, Tech Less, I train communities on healthy and safe choices on their screens. I'm also a mom of 3 boys ages 10, 14, and 16. I'm here to speak in support of this bill. After 10 years of training over 10,000 kindergarten through college-age students, plus community members, I firmly believe the burden of a safer internet cannot be solely on the shoulders of parents and kids. These companies have to bear responsibility for the access minors have to harmful content. Parents are entitled to laws which support their ability to protect their kids from harm. I knew what to do in my own home according to science, data, and experience. I delayed, set up filters, and dumbed down my kids' smartphones. But Texas parents and even myself need better support here. I always recommended filtering software to communities I train, but sometimes that's not affordable for families to take on a monthly cost. Filtering by default supports protecting minors in Texas, the families that are impacted by the digital divide specifically, and it's a common sense solution for us. With 1/3 of online videos containing explicit content now, unfiltered access puts minors at risk for mirroring what they're exposed to. In my experience, this looks like exposed children acting out on their own peers, classmates, family members. And they're also vulnerable to act out with strangers online, which social media and multiplayer games already put minors in easy contact with strangers. After I finish trainings, I give kids the opportunity to come up and talk and ask questions. And recently, a 4th grade girl came up and asked me, what if someone sent a picture that they wish they didn't? Could they go home and break their computer screen? Would that make the picture go away? Very innocently. And it was in that moment, after getting her the support, of course, it was in that moment that I realized on an even deeper level the power of these devices in the hands of minors, young enough to have no clear understanding, even something as basic as the difference between a physical and digital object. We have an opportunity here to help that young girl and so many others. I started educating on internet safety out of the lived experiences of the youth we work with, but 10 years later, the data is in, and it's impacting far more than my community, and it's not in the favor of youth health, well-being, and safety. I speak on behalf of my experience with our Texas communities. As much as educating and empowering families is important, it isn't enough for this giant that we're up against. I'm hopeful this bill will pass. I actually even have conversations with parents after my training that are upset when they see that, when I show them how to turn on filtering software, they're upset that that's not an automatic default. Thank you.
Dawn. Thank you. Mr. Raymond, you're recognized.
Good morning. My name is Jack Raymond. I'm with Prestonwood Baptist Church in Plano, Texas. Grateful for the opportunity to share. Thank you, Senator Paxton, for this bill, and I'll speak just briefly on my support of Senate Bill 417. And at Prestonwood, I have the privilege of serving as the Young Marrieds Minister at our church as I minister to many young parents in their 20s and 30s. And as I'm sure you can imagine, there's just countless challenges and pressures facing new and also young parents today all across Texas. And at the top of that list is the daily challenge to protect their young sons, young daughters from inappropriate content that is so prevalent and is easily accessible through all technology. Studies have shown, and as many have already shared personally, I just hear of so many exposure stories to pornography at a younger and younger age for all children. Personally, I'm grateful that I grew up in a home where my parents, to the best of their ability, set up parameters to protect my brothers and myself from pornography and from other inappropriate content. I was actually first introduced to pornography at the age of 17, which led to my own struggle and addiction off and on for the next 5 years. And all of that has led to this day that I continue to use several filters and accountability software on my iPhone, laptop, and all electronic devices in order to keep myself protected from pornography because of the destructive nature I've seen personally and through the lives of so many others when it comes to our own health, when it comes to our relationships, and to our very soul. And so I just close by saying that I've seen far too often the destructive impact of pornography in my own life, but in the lives of so many adults, teenagers, and now tragically even young kids. I want better for my 1-year-old daughter, and I want better for the children and the future children of Texas and all across this country. And that's why I believe strongly and support Senate Bill 417 so that we might unite together to protect our children and future children and set them all up for future success. Thank you so much.
All right. Thank you. Mr. Callender, you're recognized, and then when he's done, we'll open questions for the panel. You're recognized, Mr. Callender.
My name is Sean Callender, and I serve as the Minister of Men and Global Outreach at Prestonwood Baptist Church in Plano, Texas, as well. And thank you for the opportunity to share testimony today. And I'm sharing on behalf of Prestonwood Baptist Church, but also as a concerned dad to 3 wonderful children, ages 14, 11, and 8. I fully support Senate Bill 417, device filters for minors. And my support for this bill results from over 25 years of serving as a pastor and seeing firsthand the devastating consequences that pornography has on individuals and families. Many men I've met with who have marital issues often admit they saw their first pornographic images either as a child or adolescent and subsequently developed a pornography addiction. The objectification of women portrayed in pornography are images that are seared into their young minds. As a result, they carry these images into their marriages with destructive consequences that impact them personally and their families. A recurring theme among these individuals is that they wish they had never found these images and videos online. For this reason, we must act to protect our children with strong legislation such as the bills proposed today. Gone are the days of pornographic magazines that sit behind the magazine stand at convenience stores. Today, pornography is accessible on any internet-enabled device in a few seconds. Not only is this dangerous content prevalent online, but videos about cutting, burning oneself, ingesting dangerous products, and more serve as a gateway or trigger for self-harm. As a dad of 3 young children, I go to great lengths to protect the well-being of my kids. For example, I ensure they wear seatbelts and put a fence around our pool when my children didn't know how to swim. I did and do all these things because I care for and love them immensely. However, due to the rapid advances in technology, parents find it challenging to protect their children online in this ever-changing digital world. Requiring the automatic installation of content filters on electronic devices and ensuring these filters be affirmatively set to on by the manufacturer will provide parents the assurance that when they gift their child a tablet or phone, they are handing them a device that is safe and secure and not a device that will lead them down a wormhole of addictions. Today, we require drug companies to package drugs in child-resistant packaging because we know the disastrous effects of a child taking pills without parental supervision. The simple use of child-resistant lids has dramatically reduced child poisoning rates in the United States since their introduction in the 1970s. However, while filters for internet browsing have existed for years, devices remain unprotected for children when initially activated. Because of the well-documented harms of pornography and deadly online content, action is needed, and this bill, I believe, brings the child-resistant protection we need to guard the next generation's health. Ultimately, we know destructive online content is only increasing, but with your support, we can care for our children in the great state of Texas and set an example for the rest of our nation. Thank you.
Okay. Thank you. Members, questions of the panel? All right. Thank you all for joining us today. Safe travel back to Waco, Dawn. Chair calls Jamie Carruthers, Denise Seibert, and Servando Esparza, and then on deck, Hillary Hickland, Gregory Porter, and Jennifer Fleck. So, Chair calls Jamie Carruthers, Denise Seibert, and Servando Esparza. All right. Say again. What do you telling me? Yeah. All right, Mr. Carruthers, you're recognized.
Thank you, Chairman. Thank you, members of the committee. I'm here representing Street Grace, and we support and are for Senate Bill 417. From child labor in mines and factories to lawn darts, we have over 2 centuries of absolute proof that, as great as the free market is, and private companies are, they have no real interest in ensuring children are not harmed by their products unless it somehow disrupts profitability. I would go even further and say the bulk of the social justice posturing that mega corporations engage in is just that, posturing to distract us from some of the not so great things they do, from labor trafficking in their supply lines to environmental damage. It's the same with this issue, only now they've flipped the coin and they're going to sing a new song. It's just as insincere. Constitutionality, free market, burdening private entities. It's all smoke and mirrors. It's also hypocrisy, because there is a strong correlation between wealth and privilege in using filtering technologies. That is, well-heeled parents generally have the time and resources to use filters, while low-income parents do not. As has been said, this technology already exists, but research shows that most people leave their apps on the default settings. The reality is, most of the time they're not turned on. Children are left unprotected. 60% of first-time porn exposure is inadvertent or accidental. Common Sense Media Survey found the average age most kids are exposed to porn, 12 years old. Nearly a fifth saw it when they were 10 years or younger. 76% of teen boys admit to seeing porn, which tells us absolutely that 24% of teen boys are liars. A survey by the Center for Disease Control and Prevention has shown that 57% of high school girls experience feelings of sadness or hopelessness in the past year. That has doubled in the last decade. 30% have seriously considered suicide. 13% have tried it. Why? Social media. And they say that, and that's true, but we can't ignore the massive impact of unfettered access to pornography. Thank you very much.
Thanks for your testimony. Mr. Sparza, welcome. Introduce yourself. Give us your testimony.
Yes, sir. Chairman Hughes, Vice Chair Paxton, and members of the committee. For the record, my name is Servando Sparza. I'm Executive Director for TechNet in the Southeast region. I'm testifying today in opposition to Senate Bill 417. TechNet is a national bipartisan network of tech companies that promote the growth of the innovation economy nationwide. We understand the concerns and the intent of the bill, and the testimony is very alarming. But we have a couple of concerns with the bill. I did not get a chance to see the committee sub, but based on what was said, I don't believe that alleviates our concerns. There was testimony already said about many commercial as well as free content filtering and blocking solutions that are available for consumers to protect their families from illegal and inappropriate content. These solutions are widely available as both integrated and independent solutions for different types of technologies. However, completely reliable identification, blocking, and filtering capabilities like the ones that the bill calls for are not feasible. And what I mean by that is they're not always going to be perfect. There's over 250,000 websites that are created on a daily basis. A filter constantly needs to be updated. Some of the filters overly block sites just to be absolutely safe. And so the way that the bill is written, it requires that the filter has to be perfect because it places liability on the manufacturer when the filter is not perfect. What that also does is it places the manufacturer in the place of having to decide what can or not be blocked in a filter, which when the example that I mentioned about overly blocking situations, then the manufacturer could be charged with saying that they blocked an entire website and moderating their content. Can I add one more point, sir?
Well, Senator Paxton has a question for you, and then I will too, so we'll get to it then. Senator, go ahead.
So I know you said you haven't seen the committee sub, which I think will clarify some of your concerns. But to your point that there are widely available other filters, low cost, even free, that is certainly true. But there is nothing as widely available as the app that is already built in to the device. And this bill doesn't make the manufacturer responsible for the website content of some publisher. It makes you responsible to put the default to on. That's it. Is that does that seem like a problem that the default should be, you already have a default, it's off. Is it that hard to change the default and put it on for safety for children?
So it's not difficult there. The difficulty comes in with the liability that comes into place if the filter is not perfect.
The liability is on whether the filter default is on.
That is not the way we read it on here. That's a major
Take another
concern
look.
for us.
Take another look. That's the intent.
And Mr. President, you were on a point when you were closing. Go ahead, and I have a question for you after that.
Yes, absolutely. So one of the approaches that several bills have taken a look at this. Senator Paxton, Vice Chair Paxton, you mentioned Montana. Montana has just modified their bill that looks like this to look like your other Senate Bill 2021, which I believe is being heard shortly after. That approach makes a lot more sense to us because that is placing the age gate. You have to block this content on the providers, on the websites that maintain that type of content instead of the liability that might be placed on the device manufacturer. That was the point that I was going to make, sir.
Well, thanks for that. And you know how this process works. There are committee substitutes, and they don't come out until the bill's presented for a hearing, so we know you have to look at that. I'm just curious, and I won't ask you to commit to something you haven't seen, but the concept that the bill, the senator describes, where the machine already has a filter, let's say a filter of some type, and I realize there's a lot of details to work out, but the concept of that being set to on rather than set to off, what about that? Help us understand that. What does the industry think about that? That doesn't sound like that would be a problem, I don't think, but help us understand that.
So I think the automated of it, that is not the big problem. The problem is that it's usually accompanied with some type of liability, that if it either doesn't work properly or one of the websites wasn't properly blocked, then the liability is placed on the device manufacturer because the responsibilities were placed on them. That's a concern that we have.
Okay, thank you. Senator Paxton.
And there is a good faith clause in the bill.
Yes, ma'am. Yes, absolutely. And in pointing to that, it doesn't make it absolutely clear that just because you automate the device filter when you start a new device, that protects you from that. That's the way that we're reading it.
Okay.
Senator Middleton, go ahead.
Thank you, Chair. Wow, we've heard some disturbing testimony here today. And I've got my oldest two are 9. Baby's not even 2 yet, so.
Senator, your mic may not be.
To hear the ages here, is very disturbing. The average exposure, as little as 8 years old, 7, even younger. So you would support legislation that would put, for example, age verifications on pornography websites. Is that what I'm hearing?
So we didn't support it. The Louisiana bill that looks very similar to 2021, we worked to get to a place where we were neutral on that bill.
Okay, but you do not support the default position being to protect kids, right? Is that what I'm hearing?
No, that is not. We're opposed to the liability placed on device manufacturers for device filters there, like I mentioned.
Well, I mean, that's not what it does, as the author said. The presumption is that they have it on until you opt out, so it sort of reverses it. Right now, it's opt in. We want it as opt out, right? And that's really all this bill does. And clearly, the technology exists, not going to cost any more money. Do you work with we have another letter of opposition here from NetChoice. Do you work with that organization at all?
I'm with TechNet. That's a different.
Right. I'm just asking here. Are you working with them to oppose this bill?
We work together on a bunch of issues, but I have not even read the letter.
Okay. So what would your solution be? I mean, if this is an opt-in or opt-out bill, so why do you think that's not going to work, first of all? And why do you think it's bad policy for the state of Texas to have a default position of protecting children?
And the idea of it, I guess let me take a step back. The other concept that we talked about with 2021, the concept there is the entities that either they put this content up there, they benefit from it, that is part of what their business is, should be the ones that place the age restriction on those websites. The concern that we have here is the liability on a device manufacturer which does not create content, which is not in charge, is now being placed in a position where they have to make sure their device filter is perfect. Otherwise, it could be sued or a fee of $30,000 for each incident. That's a concern that we're coming from.
Well, but isn't it more effective to do both, though?
I mean, based on TechNet's feedback, we worked on this issue in Louisiana, like I mentioned last year. We came to a place where that type of bill, 2021, made a lot more sense.
I think we're just going to have to disagree. I think it's much more effective to do both. I think we should do both, and you're against this portion of it, and I think this is a critical component of it. And thank you, Senator Paxton, for bringing this bill.
Senator Paxton.
Well, I certainly understand anyone with something as severe and dramatic as pornography exposure. I understand why anyone would not want to be responsible. But it's everyone's job to be responsible. And it would say a lot, I think, if the tech industry, instead of taking a position of we don't want to be responsible here, instead we're saying we're going to do everything we can possibly do to protect children online. And resetting a default from off to on is the simplest thing we can possibly do. Thank you.
Members, any other questions for Mr. Esparza? Mr. LaMattia.
Thank you, Mr. Chairman. I had a question. You mentioned, I believe, Louisiana, Montana. Are there any other states that have similar filters like this that are defaulted to on, or any other states that handle this issue?
So Utah passed a bill, but their bill does not go into effect until at least 5 states enact it. On the Louisiana model, thus far, we've seen Arkansas move towards it. Florida is moving through the process. As I mentioned, Montana just recently modified their device filter bill to be, we call it age verification bill. So the language in 2021, Montana subbed that over. Other than that, I think I can't name the full list, but that's sort of kind of with the shape of some of the states that I know of.
Thank you, Senator. Thanks for your testimony. Ms. Seibert, go ahead. Everybody just hold tight in case we have questions at the end, but Ms. Seibert, go ahead. Thanks.
Okay. My name is Denise Seibert. I represent myself. I support SB 417, the filter to block porn on children's devices. Digitally sex trafficked. That's a good quote that the mother said. I grew up around Hollywood and almost nightly saw prostitutes on the streets. Now we have it coming into our homes. This is a common sense bill. I agree with having an automatic filter enabled to prevent a minor from accessing, downloading, and displaying explicit material such as porn through the mobile data network, internet, or Wi-Fi. Parents can't be there every moment the child's using the device. Children are getting phones at younger ages and may not understand to be watchful while searching. Children are always curious, and when searching, explore the internet for information, may come across porn. I remember sometime around 2000, while I was searching on the web on my home computer, I had porn flash across my screen. Training up a child in the way he should go, and when he is old, he will not depart from it. Proverbs 22:6. The internet is a swamp of information that bombards the child's mind with information and not always appropriate information. I hope this filter will be enabled to protect children here in Texas, giving the parents the confidence that their child will be safe when using their devices. I support SB 417, automatic filter to block porn on devices. Thank you, Senator Angela Paxton. And I thank all of you that gave your personal testimonies. Thank you for being brave and speaking the truth of how it harmed you and your families.
Thanks for your testimony. And Senators, any questions for any of our 3 witnesses? We thank you each for being here. Any questions? All right, thank you. Thank you very much. The chair now calls Hillary Hicklund, Gregory Porter, Jennifer Fleck. Again, Hillary Hicklund, Gregory Porter, Jennifer Fleck. And those are the last remaining witnesses we have registered to testify on for or against Senate Bill 417. If anyone else wishes to, make sure and sign up at the kiosk or register on the kiosk outside the doors. All right, welcome. We'll start over here on my left, your right. Introduce yourself. Give us your testimony.
Thank you, Chairman, and thank you, Senator Paxton, for filing this bill. My name is Jennifer Fleck. I represent myself as a parent and Texas Education 911. we are for this bill. The brain is mysterious and amazing, as there are certain moments in my life that have made an indelible, unforgettable mark. I remember exactly where I was and who I was with when I first heard that President Reagan had been shot, when I first heard that the Space Shuttle Columbia had exploded, and when I first heard about 9/11, and when I first saw sexually explicit material as a child. It made a mark. I remember when my youngest son told me how his friend had shown him pornography at the age of 8 years old on his phone. It's an evil day we live in while this session has a record number of bills filed to protect children from sexually explicit material. This is a clear agenda for the destruction of our children's innocence. Like Senator Paxton has mentioned many times, this is an easy toggle change, and we're asking this legislature to protect children and ultimately protect families. Thank you.
Thank you, Ms. Porter. Welcome back. Introduce yourself. Give us your testimony.
Thank you. Gregory Porter. I'm here on behalf of Texas for Liberty and the Texas Liberty Council. And I want to make a note to the clerk. I think I accidentally hit against because I am taking a position against, I think, another bill that's going to be presented. But I'm speaking on behalf of this bill, for this bill. Yeah, just want to make that correction. If it's incorrect. So yeah, thank you for the authors here, Senator Paxton, Senator Middleton. This is a very sensible approach to restricting this content. I think a very important bill to protect Texans. The one thing that I just wanted to share, I don't really have anything additional to offer. I'm so grateful for all the testimony that's been here. Just an incredibly important issue and a very well constructed and conceived bill. So I appreciate that. The one thing that I want to just mention, just as an aside to consider, is we've got this filter on a cell phone now, and I just want to make sure, given the nature of all the censorship that we've seen and the egregious nature of some of that content over the course of the last few years, that maybe we might want to put just a note in here that just says that there's nothing else, that these filters could actually be used for except for this sexually explicit content. So I know that the bill specifically calls that out. I just want to make sure as we think through carefully as we're, requiring these to be on the phones, that we want to make sure that that kind of filtration could not be used for any other mechanism of censorship. But in whole, I really appreciate the sensibility of the bill. It's well conceived and really appreciate all the efforts that's gone into it. Thank you so much.
Thanks for your testimony. Welcome. Introduce yourself. Give us your testimony.
I'm Hillary Hickland. I serve on the subcommittee for the Republican Party of Texas to stop the sexualization of Texas kids. I'm representing myself in support of this bill, and I'm here to read the official statement from the chair of the subcommittee, Kristen Bentley. The state has a compelling interest in protecting Texas children from pornography, which is extremely harmful to their social, emotional, and physical development. This interest is well established in the Texas Penal Code 43.24, which makes it a Class A misdemeanor to sell, distribute, or display harmful materials to minors. Despite this, Texas children are more likely than ever to be exposed to pornography, as advances in technology have made it more prevalent and normalized than any other time in history. Exposure to pornography is most likely to occur on the internet, which is easily accessed on cellular devices, including phones and tablets. These devices are now ubiquitous to American children, as cellular companies have been marketing to them for years. A recent Stanford study found that most American children have their own cell phones by the age of 11 years old. Through cellular devices, children have access to the digital world where pornography is readily available, oftentimes free and easily accessible. It is so common that many internet users are now unwantedly exposed to pornography. Unwanted exposure can be traumatizing to an adult, let alone a child. Exposure to harmful materials on cellular devices can easily be prevented through device filters activated at the time of purchase, and these protective filters could be the default. SB 417 does this by requiring that cellular devices activated in the state of Texas automatically come with a device filter for pornography. It ensures compliance through both civil and criminal penalties. Commercial entities operating in the state whose products or services come at a reasonable risk of exposing children to pornography should be made to take steps to prevent unwanted and criminal exposure. Thank you.
Thanks for your testimony. Members, any questions for our witnesses? Thank you each for being here. Those are all the witnesses we have registered to testify on, for, or against Senate Bill 417. Is there anyone else present wishing to testify on, for, or against Senate Bill 417? Seeing and hearing none, public testimony is closed, and we'll leave the bill pending at this time.
Chair, I had a
Senator Miller, go ahead.
Thank you, Chair. Is there anyone from Net Choice here? They dropped a letter to the committee. There's no one here? Okay.
Is there anyone here from Net Choice?
I just felt like they needed to answer some questions because they essentially said at the end of their letter that stopping children from being hurt would cost jobs in Texas, and they had economic reasons for being against this bill. So I think they should answer those questions, but I guess they're not here to do that. No.
I'd like to know too. I'm glad you pointed that out. Yeah. They did not register wishing to offer testimony. I think they must have just phoned it in. The chair now lays out Senate Bill 2021. Senate Bill 2021, and recognizes its author, Senator Paxton, to explain the measure.
Thank you, Mr. Chairman. Thank you, members. Members, you've already heard me talk somewhat at length about the dangers of pornography, particularly for minors, in my last bill layout, so I won't be repetitive on those points. But I've brought 2021 because it provides an additional approach to protecting our children from pornographic material on the internet. And it's modeled after an age verification law in Louisiana, which some of the witnesses mentioned in testimony on the last bill. Currently, in the United States, since January 1st of this year, when Louisiana's age verification law went into effect, over a dozen states have introduced age verification legislation for pornographic websites on the internet. Arkansas, Virginia, Florida, South Dakota, West Virginia, Kansas, and Mississippi have all introduced legislation virtually identical to the Louisiana bill. And Oregon, South Carolina, Minnesota, Utah, Oklahoma, Missouri, and Arizona have also introduced or plan to introduce age verification legislation. And it makes sense. Senate Bill 2021 simply does this. It requires a publisher or distributor of sexually explicit website content to create an 18-plus age verification in order to view the website content. That's all it does. Similar age verifications are already used around the world, in the United States and around the world, to prevent minors from things like online gambling, online purchase of alcohol, online purchase of cannabis. The user's data is not retained after the verification, but just to be very clear, there are already proven mechanisms for accomplishing this age verification process. Due to the highly addictive nature of pornography in general, and especially internet pornography, just like with cigarette warnings, health warnings, this legislation would require that the publisher and distributor of sexually explicit content show a Texas Health and Human Services warning prior to viewing the explicit content page. And this language is laid out in the bill specifically. Gambling websites in the United States are required already to display information about responsible gambling and provide a helpline for individuals who may be experiencing problem gambling. Something for us to all kind of consider this session as well. The helpline number is usually displayed prominently on the website. Members, we know that many adult porn users who certainly by right have access to this material and will not be limited in their ability to access it with this age verification. But we know that many, many porn users feel caught in a losing battle against their porn addiction or what may be becoming a porn addiction. This bill requires the publisher and distributor to show a porn addiction help page and number on all the web pages. I do have a committee substitute for Senate Bill 2021.
The chair lays out the committee substitute and recognizes the author to explain the substitute.
Thank you, Mr. Chairman. The committee substitute for Senate Bill 2021 simply adds an enforcement mechanism and a penalty to the publishers and distributors who do not comply. Thank you, Mr. Chairman and members, for your consideration and favorable consideration of Senate Bill 2021 to keep minors safe online.
Thank you, Senator. Members, any questions for the author before we begin testimony? Beginning with invited testimony, the chair calls the following witnesses: John Schwepp, Deborah Simmons, Jack Raymond, and Sean Callender. Again, we're looking for John Schwepp, Deborah Simmons, Jack Raymond, and Sean Callender. Welcome. We'll start over here. Introduce yourself and give us your testimony.
Good afternoon. My name is John Schweppe. I'm the policy director at American Principles Project, a pro-family conservative group based out of Virginia. I'm proud to be here today in support of SB 2021, a bill that will protect kids online and provide important peace of mind to parents who are struggling to safeguard their kids' innocence, especially in a culture so hell-bent on sexualizing them at earlier and earlier ages. This is an age verification bill that would prevent minors under the age of 18 from viewing explicit content online, and by that we mean pornography. The bill would hold distributors and publishers of obscene content liable if they failed to implement a functional age verification system, meaning that parents would have the right to sue when a porn site sends obscene content to a child. Almost everyone here should be able to agree that we don't want kids accessing online porn, just like we don't want kids smoking, drinking, or gambling. I'm from a state that has legalized sports betting, unfortunately, and kids can't place bets because FanDuel, DraftKings, and all the other sports betting apps have age verification software in place. This protects kids from picking up an addictive habit before their brains have fully developed and matured, and it's not an undue burden on adults. It's still extremely easy for an adult in Virginia to place a bet. But frankly, protecting kids from porn is more important than protecting them from cigarettes, beer, and gambling. The need for this legislation is obvious. According to one study, the average age of first exposure to online pornography is now just 12 years old. Meanwhile, numerous studies have linked porn use to mental health issues, relationship issues, and sexually abusive behavior. And because I know the upstanding folks here today probably aren't familiar with modern online pornography, let me inform you, what you see on the internet today is nothing like the Playboy and Hustler topless gals of yesteryear. The internet made porn really, really weird. The number 2 search for porn in the United States is hentai. That's cartoon pornography. Hentai means strange appearance in Japanese, and that's basically what you get. This is the most psychologically disturbing pornography on the internet, and it's being targeted directly to kids. Because it's cartoon porn, there are no real-world limitations, meaning that kids are being exposed to the most violent, sadomasochistic pornography imaginable. Kids get addicted to this stuff extremely quickly, and it completely warps their view of sexuality and of potential romantic partners. And again, I can't stress this enough. This type of porn is being deliberately targeted at kids with no recourse for parents. Texas families need this bill to pass. It's common sense. It should be bipartisan. Parents can't shoulder this responsibility all by themselves. Devices are everywhere. The internet is everywhere. And Texas wouldn't be standing alone. Lawmakers have introduced this type of legislation in at least 18 states across the country. In just the last several months, we've seen age verification laws pass in Louisiana and Utah, and we expect bills to soon be signed in Arkansas, Mississippi, and possibly even Virginia. It would be incredible to have the great state of Texas join that list. I appreciate all the important work this committee is doing here today. On behalf of American Principles Project, I urge the immediate passage of SB 2021. Let's hold these porn sites accountable. Thank you.
Thanks for your testimony. Welcome. Introduce yourself and give us your testimony.
I'm Deborah Simmons, and I am for Senate Bill 2021 to require reasonable age verification methods for social media platforms and internet websites. As a mom with 10 years experience in the IT industry, I was alarmed when I became aware of the porn industry targeting minors online, particularly in schools. I used my skills in enterprise systems, network technologies, and supply chain to research accessibility of sexually graphic images, explicit text, and embedded hot links in databases and portals, often using VPN access to emulate the average customer experience. Network filters are inadequate to anticipate and prohibit access to every new website, every online environment, and each hot link embedded in what is marketed as curated safe portals for K through 12, including hot links to actual porn sites. The peddlers of pornography, child sexual abuse material, and obscene content do not have boundaries in their efforts to expose children and corrupt their young, impressionable, and innocent minds. The American Library Association and allies often preach freedom to read, freedom to access, and freedom to view to circumvent all protective factors for children, including their own parents. Opposition organizations align with the adult industry, entertainment industry, and coalitions such as the National Coalition Against Censorship and Every Library to fight all efforts to protect children. This legislation provides necessary safeguards that the industry and their allies refuse to do voluntarily. The essential criteria should be to protect minors. Do not be persuaded by the false accusations of censorship and guarding of First Amendment rights. The focus of this legislation is, as it should be, to protect minors. Texas has a compelling interest to protect minors, and we applaud the efforts of the 88th legislature to pass each and every piece of legislation to that end. Age verification on adult websites is a necessary and powerful solution. Thank you.
Thanks for your testimony. Welcome back. Introduce yourself. Give us your testimony.
Good afternoon, and my name is Jack Raymond, and I represent Prestonwood Baptist Church in Plano, Texas. Again, I serve there as young married pastor, and so I serve with a lot of young couples and young families and young kids. And so just wanted to voice again my support as well of Senate Bill 417 and this bill, Senate Bill 2021. Just say thank you to all who are fighting just for the protection and the safety of our children and of the next generation. And it's been mentioned multiple times, obviously the age and introduction to pornography continues to be a younger and younger age. And so I believe strongly that bills such as these will help reverse that trend, and where we can see the protection of our children and of the next generation here in Texas. And just wanted to share as well, grateful to see in this bill the inclusion of a porn help. We at Prestonwood started a ministry a few years ago called Life Recovery, because it's such a prevalent, especially in light of COVID-19 and so much additional time that people spend on screens and technology. It's just immensely important to be able to help both minors and those who are adults that are addicted, struggling, hurting, and feel like there's no hope. So grateful for Senator Paxton and for all fighting for the next generation. Thank you.
Thanks for your testimony. Welcome. Introduce yourself and go ahead.
Once again, my name is Sean Callender. I serve as the Minister to Men and Global Outreach at Prestonwood Baptist Church in Plano, Texas, and I fully support Senate Bill 2021 and grateful for Senator Paxton introducing this bill, and our church fully supports this bill. Unfortunately, I meet with adults annually who indicate they were exposed to this explicit content when they were children or in their adolescence, not knowing the impact that pornography has psychologically and physiologically on their minds and on their bodies. With the ubiquitous use of internet-enabled devices by children, it's critical that we care for the well-being of our children by requiring age verification on pornographic websites. Today, pornography is known really as the triple threat to our children. It's accessible to children through a few simple clicks, and once accessed, it's viewed anonymously without their parents' knowledge, and thus leads to concealed addictive behavior they struggle with well into adulthood, which impacts their families with devastating results. Unfortunately, the fence is far too low to keep children from accessing this content in Texas. It's also affordable because many of these porn-producing websites create content that's initially free to lure people into this dangerous world. However, support of SB 2021 will place a warning on the landing pages of sexually explicit websites and require age verification prior to viewing this content, and will deter children from accessing this harmful content, which was created by adults and not intended for children to view. So thank you.
Thank you for your testimony. Members, any questions for our witnesses? Thank you each for being here. Thank you very much. We'll now open public testimony, and the chair calls Denise Seibert, Fernando Albornoz, Hillary Hickland, and Jennifer Fleck. I see we have Ms. Seibert coming. We're looking for Fernando Albornoz, Hillary Hickland, and Jennifer Fleck. Ms. Seibert, welcome back. When you're ready, go ahead and introduce yourself. Give us your testimony.
My name is Denise Seibert. I represent myself. I'm in support of SB 2021, age limits on porn content on websites. There should be responsibility taken for anything that's published on the web. There should be an age verification legislation requiring 18+ verification for sexual content. We have that in the movie ratings, so parents are aware. I agree with the help phone number to help all ages in fighting porn addiction. My husband's family and himself has had struggles with addiction, smoking, drinking, gambling. It hurts and affects the whole family. We need to protect our children from porn. As we've heard these other kids speaking about when it started at their young age and the struggle they had, we need to do that. Again, parents can't be there every moment the child is using the device. The children are getting phones and everything else, younger and younger, and we need to show them that we respect them in having this web page that will stop them. So Lord, we just training up a child in the way he should go, and when he is old, he will not depart from it. Proverbs 22:6. We need to have those age limits, so I support SB 2021 with the age limits on porn content websites, and thank you, Senator Angela Paxton, for this bill.
Thanks for your testimony. Mr. Albornoz, introduce yourself. Give us your testimony.
Mr. Chairman, honorable members of the committee, my name is Fernando Albornoz. I am representing myself and speaking in favor of the bill. I want to commend and thank Senator Paxton for her leadership in introducing this legislation. I want to briefly talk about the federal laws that govern the pornography situation in the United States. And I believe that if that Supreme Court knew today what was available today, it would have decided differently. In 1997, the Supreme Court struck down the Communications Decency Act. Importantly, this is an act that was signed into law by a Democrat, President Clinton. It was vigorously defended before the Supreme Court by a Democrat Attorney General, Janice Reno. The law provided protections to prevent children from having access to pornographic material. At that time, it was viewed that the internet was an emerging technology, that it needed protection against excessive regulation, including things such as the Communications Decency Act. Today, the internet has become a leviathan. It is massive, it is wealthy, it needs no protection. If anything, we need protection from it. In terms of the First Amendment issue, in writing the majority opinion, Justice Stevens spoke very adamantly about the need to protect the constitutionally protected First Amendment right to have access to information, including any adult that wanted to have access to pornographic material. What they didn't appreciate is the impact that the internet would have on children. The porn industry has developed into a multi-billion-dollar business, and children today have access to electronic devices that give them unfettered, unlimited access to pornography. This is a magnificent bill. I think it would greatly improve the quality of life of children in Texas. And if it met a constitutional challenge, I am convinced that it would find a safe harbor today in the Supreme Court. Thank you.
Thank you for your testimony. Welcome back. Introduce yourself. Give us your testimony.
Hillary Hickland. I serve on the subcommittee to stop the sexualization of Texas children for the Republican Party of Texas, and I'm here to read the official statement on behalf of my committee woman, Kristen Bentley. The Republican Party of Texas strongly supports SB 2021. The availability of pornography on the internet has made its consumption ubiquitous among adults and adolescents. The statistics are startling. The average age of first exposure is around 11 years old, although some research has shown the average age is 8 years old. Either is unacceptable. With an estimated $16.9 billion yearly revenue in the United States alone, the pornography industry is both massive and powerful. The financial and social costs associated with its misuse and addiction are difficult to measure, although we know that porn addiction is becoming an epidemic level, affecting about 5 to 8% of American adults. Children exposed to pornography are at particular risk. They report feelings of disgust, shock, embarrassment, anger, fear, and sadness after viewing it, and can suffer from anxiety and depression and other mental health conditions as a result. Children exposed to pornography at a young age are statistically more likely to sexually assault their peers and suffer a broad range of maladaptive, violent behaviors. The state of Texas has a compelling interest in protecting children from pornography. This is well established in Texas Penal Code 43.24, which makes the sale, distribution, and display of harmful materials to a minor a Class A misdemeanor in the state. With the advent of the internet, the pornography industry has shifted to selling, distributing, and displaying their harmful materials in the digital world. And yet, there is little to no protection for Texas children who also use this public domain. SB 2021 responds to the advances in technology by placing stringent age verification measures for viewing online pornography. Commercial entities would comply because of the strong enforcement measures. Thank you.
Thanks for your testimony. Welcome back. Introduce yourself. Give us your testimony.
Thank you. Thank you, Chairman and Senator Paxton, for filing this bill. My name is Jennifer Fleck. I'm testifying on behalf of myself and Texas Education 911. We are in strong support of SB 2021. As I mentioned earlier, I remember, and I think probably most people remember their first exposure to sexually explicit material, graphic pornography. And if this bill will prevent an accidental exposure, which I think happens a lot amongst minors, it even happens in the schools on the prolific now one-to-one devices that are provided to all of our students. If we can stop that, that would be amazing. And two things that I'm hoping in this bill will prick the conscience of any user, which are the age verification. It might stop even someone who isn't a child, make them pause and ask if this is really what they want to do. And then in addition, the warning, to have to read through that, it really makes you stop and think, I hope, right? So especially children, I think they'll see that warning and it'll make them pause, but even an adult. So thank you so much, Senator Paxton, for filing the bill.
Thank you for your testimony. Senators, any questions for any of our witnesses? Thank you each for your thoughtful testimony. Thanks for being here. The chair calls Joseph Haas. Joseph Haas. Mr. Haas is the last witness we have registered on, for, or against Senate Bill 2021. So this will be the next to the last call for anyone wishing to testify. Mr. Haas, welcome. Get situated there, then introduce yourself. Give us your testimony.
Yes, thank you. Yes, my name is Joseph Haas. I'm from Dallas, Texas, and I represent myself. So I just wanted to share a couple of thoughts on this. I personally have seen, this is anecdotal, but I've seen a surprising uptick in those who consider it appropriate to show sexual content to children. I was speaking to one of these people recently, and this person's rationale for it was that she had been exposed to sexual content as a youth, and she turned out balanced. In my assessment, it is not balanced to be okay with showing sexual content to children, right? I also think it's not a coincidence that there's been an increase in mental health problems. Society is focused on continual tech progress. We even have forms of AI now, and AI-generated porn. What is going on if we have all these progressions if we're not protecting children? It just doesn't make sense. I'm grateful for SB 417 in 2021, but I'm sure it won't have to stop there. We'll probably have to do more to protect children. Thank you.
Thanks for your testimony. Members, any questions for Mr. Haas? Senator Paxton, go ahead.
Thank you, Mr. Chairman. I appreciate your testimony, and as you were sharing, I was thinking about all of the things that all of the witnesses have spoken today, and there's quite a bit of evidence, at least that I see, and I'd like to know your thoughts on this, but that online pornography addiction is much, the effects of it are much more pronounced than what we all probably used to think of as pornography, the Playboy, the Hustler, and that sort of thing. Would you agree with that statement?
That the side effects of watching pornography are worse than what we would.
That the online iteration of this is much more harmful than simple print.
I personally believe a lot of societal harms that we're all perceiving and going on around us and are shocked by find a lot of the roots in mental illness being, finding its way into people's lives because of their exposure to pornography. As was mentioned earlier, some of these types of pornography are unbelievably disturbing. And people find their way into that, and then they end up in very unhealthy mental places.
Members, I don't know as I've been studying this issue with both of these bills, as a school counselor as well, it is incredibly disturbing. And the online version of pornography is, the research base is that it is much more damaging than print pornography. Internet porn users experience much more severe side effects or results than print pornography. Part of that is the 3 A's of addiction, which are accessibility. Think about the difference between having to go somewhere and buy something or just on your phone. Affordability, you have to pay for something, versus online, as it's already been testified, many of these sites offer material for free, content for free, to get people kind of connected to it. And then finally, and maybe most damaging, anonymity. You have complete anonymity online. And so those are the 3 A's of addiction, and you can see the difference between print versus online. I think we've seen the legislature over the last few sessions grow in its awareness of human trafficking and the problem that it is in our society. I was talking to one of my daughters. I have 4 children, 3 daughters. They're all of my kids are grown now. But one of my daughters shared with me that when she was at Texas A&M as a student, she went to a presentation that was around raising awareness of the problem of human trafficking. And she reminded me of this when I talked with her just the other day. And she said, "Mom, I will never forget this young woman standing up." And she said, "If you want to stop human trafficking, stop using porn. Stop using porn." So the domino effects of the pornography that is online for adults and for children is severe. But certainly the best thing that we could do is to stop it before it starts and do everything we can with a bill like Senate Bill 2021 to protect children while they are children from getting sucked into something that's so damaging for them and has ripple effects that are really very endless. Thank you.
Any other questions for the witness? Thank you for being here. Thanks for your testimony. Is there anyone else present wishing to testify on, for, or against Senate Bill 2021? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair now lays out Senate Bill 60, and recognizes its author, Senator Zaffarini, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 60 relates to operating agreements between holders of a distiller's and rectifier's permit and certain alcoholic beverage permit holders. Members, distillers increasingly are focused on creating appealing packaging and minimizing costs by increasing economies of scale. Many would like to accomplish these goals using contract distilling, a practice in which 2 or more distilleries share manufacturing, packaging, and selling costs. Current law allows wineries and breweries to use similar practices. Senate Bill 60 would encourage business growth in an industry that in 2020 produced approximately $948 million in gross state product and more than $334 million in payroll, supporting approximately 4,900 Texan jobs. Generally then, this Senate Bill 60 would allow distillers to enter into contracts to manufacture, bottle, label, package, and sell distilled spirits. Mr. Chairman, there is a committee substitute, but I'd like to send it up at this time and not adopt it because we're still working on another version. I'd like to leave the bill pending, but just so people will know what's in this draft of the committee substitute.
Senator Zaffarini is recognized on the substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, this committee substitute, although it will change in the second draft, would ensure that if a distillery contract distills with another organization, the other organization cannot sell the distillery's liquid, but has to ship it back to the contracting distillery for sale or transfer, and clarify that the bill applies also to the distiller or rectifier's affiliates. Again, we're working on another committee substitute, and we'll bring it up, I hope, at the next hearing. Thank you, Mr. Chairman.
Thank you, Senator Zaffarini. Members, any questions for the author? Hearing none, we'll open up testimony.
Which witness? Let me see. No, we have 3 support.
Open public testimony, and the chair calls Jared King, Anthony Gonzalez, Stephanie Houston, and Ed Johnson. Again, we're looking for Jared King, Anthony Gonzalez, Stephanie Houston, and Ed Johnson. Hello, introduce yourself. Give us your testimony. Go ahead.
Hi, good afternoon. My name is Tony Gonzalez, and I'm representing Treaty Oak Distilling. I'm here today in support of SB 60. As you may know, Texas is home to some of the finest distilleries in the world, and the state has a rich history of producing top-quality spirits. Contract distilling, also known as private label distilling, is a practice where a distillery produces spirits and products for another distillery, a practice that is already commonplace in brewing and winemaking. There are many benefits to contract distilling in Texas. Firstly, it allows smaller brands and entrepreneurs to enter the market without the large capital investment required to start their own distillery. Contract distilling gives these brands access to the expertise and equipment of the established distilleries, enabling them to produce high-quality spirits that can compete with the best in the business. Excuse me. Secondly, contract distilling provides a valuable source of income for Texas distilleries. By offering their service to other brands, distilleries can increase their revenue and make use of their equipment during downtime. This helps to create a sustainable business model for the distillery and in turn contributes to the growth of the local economy. Furthermore, contract distilling can promote innovation and creativity in the spirits industry. When brands collaborate with a distillery, they can experiment with different ingredients, barrel types, and production methods, creating new and unique products that appeal to a wider audience. This experimentation drives the industry forward, keeping it fresh and exciting. In conclusion, contract distilling will allow us to keep Texas dollars in Texas. By offering our service to local brands, we can ensure that revenue generated stays within our state, contributing to the growth of our local economy. This is a win-win situation for everyone involved, as small brands can access the expertise they need to succeed, while Texas distilleries can increase their revenue and keep our economy thriving. As a representative for Treaty Oak, I ask that you support Senate Bill 60.
Thanks for your testimony. Welcome. Introduce yourself. Give us your testimony.
Hello, my name is Stephanie Houston, and I'm here today testifying in support of SB 60 on behalf of the Texas Distilled Spirits Association and myself. I'm the president and co-founder of Island Getaway Rum in Dripping Springs. And this particular bill is really important to me at this time due to the evolution of my own personal distillery. I just recently returned from a trade mission to Japan with the Texas Department of Agriculture. And that trip alone could possibly afford us a potential of up to 4,000 new accounts where we would export thousands of gallons of rum made here in Texas to Japan. Additionally, we have 5 other international trade missions that we're doing with the USDA to send Texas-made rums to all over the world. We would love to partner with a larger Texas distillery to make sure that we can still make this rum here in Texas. Right now, we can contract outside of the state, but I would love to keep our Texas rum made in Texas. This bill would help us grow exponentially, but it would also support another distillery that has capacity to be able to manufacture those types of products at that scale. Again, this is important for us from the sales side. It's important for Texas manufacturing, for the economic side, and I'm here to fully support this. I'm happy to answer any questions.
Thanks for your testimony. Welcome, introduce yourself, and go ahead with your testimony.
Hi, my name is Jared King. I'm here representing Spirited Cocktails Corporation. I am also here to support SB 60 in favor of contract distilling. Allowing contract distilling helps support Texas brands and Texas producers and distilleries. Like it was previously said, the money that it generates stays in the state. Texas and Austin specifically are home to one of the most thriving CPG communities in the country, many of which are in the hard seltzer, low ABV, distilled spirit space. And currently these brands are forced to produce their products out of state and absorb the cost of importing and shipping them back into Texas, or try to meet the extremely high barrier to entry and build their own production or distillation or canning facility. With the supply chain and the fuel costs the way they are, it makes the situation less attractive for Texas-based brands to start up and grow in the state of Texas. Even out-of-state brands see Texas as a great market for business and would benefit from this bill, allowing them to produce closer to the end customer, reduce freight costs, and ensure peak product quality, and also generating revenue for Texas distilleries that are making these products. The hard seltzer and low ABV market is a $17 billion segment, and by passing SB 60, Texas brands will spend their money in Texas with Texas producers and reduce the barrier to entry that will allow this growing segment to flourish in Texas. Thank you.
Thanks for your testimony. Senators, any questions for the witnesses? Thank each of you for being here. Thanks for your testimony. Is there anyone else present wishing to testify on, for, or against Senate Bill 60? Seeing and hearing none, public testimony is closed. And Bill, left pending at this time while the author works on the substitute. Thanks, Senator.
Thank you, Mr. Chairman and members.
The chair now lays out, as a matter of pending business, the chair now lays out Senate Bill 998. It's on the agenda for today, 998. This is Senator West's bill, which I'm pleased to lay out on his behalf. Senate Bill 998 is to make sure that those folks who hold a TABC license to serve alcohol are trained to recognize the signs and symptoms of an opioid overdose and to administer an opioid antagonist. More than 1,600 Texans died of unintentional synthetic opioid-related deaths in 2022, according to the Department of State Health Services. Many of those deaths, sadly, are among casual drug users who do not realize the colloquial slogan that one pill kills. That's definitely true. And the synthetic opioid fentanyl is most commonly associated with a handful of illicit so-called party drugs, such as cocaine, and then ecstasy, normally traditionally distributed as a tab or in pill form. These drugs are commonly consumed in nightclubs, bars, and other places where alcohol is served and which are regulated by the Texas Alcoholic Beverage Commission. There's a committee substitute, which I'll add at this time. Senators, the original bill required TABC to include this training on recognizing opioid overdoses for all persons who take the approved seller training program. After working with the Restaurant Association, some changes are made to the bill. As now written, the substitute would require only those persons who hold a seller certificate and work for a private club permit holder or mixed beverage permit holder, which is not classified as a restaurant under the TABC, under the Alcoholic Beverage Code, to receive this training on an annual basis. TABC would still be responsible for creating the training. This bill was originally to target clubs and bars where those party drugs, if you will, are most likely to contain fentanyl and result in an opioid overdose. It was never intended to apply to traditional restaurants, and so the committee substitute narrows the focus to its original intent. I will yield for your questions. And the chair calls Kelsey Strofert from the Restaurant Association on the bill. And no one is registered to testify for or against the bill. I'll ask if there's anyone present wishing to testify on, for, or against Senate Bill 998. Seeing none and hearing none, public testimony is closed. The bill is left pending at this time. The chair now lays out Senate Bill 2275. 2275. Senators, this bill has to do with separation of powers, and it repeals one subsection of a statute. That's the subsection that says the court can repeal a law if they pass a procedural rule that conflicts with a statute. Here's the subsection we would like to repeal. It says, so that the Supreme Court has full rulemaking power in civil actions, a rule adopted by the Supreme Court repeals all conflicting laws and parts of laws governing practice and procedure in civil actions, but substantive law is not repealed. At the time that the Supreme Court files a rule, the court shall file with the Secretary of State a list of each article or section of general law or each part of an article or section of general law that is repealed or modified in any way. The list has the same weight and effect as a decision of the court. End quote. That's the subsection we're dealing with. For one thing, this is likely a violation of separation of powers, as it gives the court, which is part of the judicial branch, the power not just to overrule, but to repeal laws passed by the legislative branch. Whether that's a violation of constitutional separation of powers or not, the statute limits the court's ability to repeal laws to only procedural laws and not substantive laws. But as a practical matter, it will be the court that determines what is procedural and what is substantive. And so that's really not acceptable. The Texas Constitution gives the court the authority to make rules, and the court's done a fine job of this over the last 150 years. But the authority that we as a legislature have granted by this statute to repeal a statute is not in keeping with our own authority to set the parameters of the court's authority. If a rule, whether procedural or substantive, conflicts with a statute, the statute must prevail. That's how our system works. That's all this bill does, and I'll yield for questions. We'll open testimony on Senate Bill 2275, and the chair calls the following witnesses who signed up for public testimony: Steve Bresnan, Lisa Hobbs, and Sean Hall Laquona. Mr. Bresnan's here. We're looking for Lisa Hobbs and for Sean Hall Laquona. There she is. And so, Mr. Bresnan, if you're ready, or when you get set up, you go ahead and start at your convenience and introduce yourself, even though we know you. Give us your testimony.
Thank you, Mr. Chairman. My name's Steve Bresnan. I'm here today on behalf of myself. A little history. Back in the 90s, when I was Governor Bullock's general counsel, the legislature was constantly being asked to pass bills that were basically about civil procedure. And at that time, I recommended to Governor Bullock that we ought to put a stop to that, since the Supreme Court had been granted authority over civil procedure back in the 1940s. And if the legislature was going to use its time and effort and political capital on that, then we should, for every time that was done, we should put in the law a provision that said, notwithstanding 22004C, the court can't do anything to change this particular statute. I counted earlier today, there's at least 16 times, maybe 17 times since that time that the legislature has done that. So selectively having to go back and withdraw that authority when the legislatures had to deal with it. A couple of weeks ago, I testified over in the House on a bill by Representative Burrows about statutory construction. And it was really about the legislature, the relationship between the legislature and the court. And the court's gone pretty far astray on that, in my opinion. So this is another example and calling attention to another example where I think the legislature needs to review its relationship with the Supreme Court. This particular statute's been in effect for over 80 years by my count, and I think could stand a little review. I would tell you in the Constitution that grants the authority to the court, authority over procedural rulemaking, it says not inconsistent with the laws of this state. And that's been held by a previous Supreme Court to mean that the legislature has the trump card on these matters. So I support your bill. Very much appreciate you doing it. I think we need a more methodical and more complete discussion about the relationship between the legislature and the court. And I hope somebody will do that during some interim when I'm still working. Thank you.
Thanks for your testimony. Ms. Laquona, introduce yourself. Give us your testimony.
Yes, my name is Sean A. Hall Laquona. I'm here to testify on Senate Bill 2275, and I'm here to celebrate. Whether you understand what I'm saying or not, I pray that you come to understand. This is a great day in history. 1824, the flag, before this state was a state, had the numbers 1, 8, 2, 4. If you add them up, it comes to 15, according to my math. Before the numbers on the flag were 1824, there was a picture of an eagle, a snake, atop of a cactus. There was a prophecy, there was an understanding from a dream that this day would come. Well, this day is here because there's been a great victory for this nation, for this state. And I'm here to tell you that this is reality. I am of a sound mind, having the spirit of love and power. I will continue to speak this truth forevermore. The eagle has eaten the snake atop the cactus. 1824 has come to 2023. Love reigns in justice. I stand on SB 2275, knowing in God we trust. Be steadfast individuals with undivided interests, having clean hearts and serving God. Saying, little children, keep yourselves from idols. This is soft ground. I just say catch up. What do I mean by catch up? That means as I leave this word, as I speak this testimony, I have confidence that each one of you, doing all your part, will understand what is being said and what has happened and make sense of it. The man to my right, I don't know him. The woman to my left, I don't know her. But I honor what they are here to say, and speak. Thank you.
Thank you for your testimony. Welcome. Introduce yourself. Give us your testimony.
Good now afternoon. My name is Lisa Hobbs, and I am here on behalf of myself. I am a board-certified civil appellate lawyer here in Austin, Texas, with my own appellate boutique, Kuhn Hobbs. I have been involved in the Texas Supreme Court's rulemaking function almost since I have been licensed as an attorney over 23 years ago. I started as the court's rules attorney in 2004. I was their general counsel. And I've since been a member of the Supreme Court Advisory Committee since I left the court in 2008 to the present time. I've been a member of the Supreme Court Advisory Committee, as well as being involved in various things, like with Senator Zaffirini as the rules advisor on the Access to Justice Commission. I've seen the relationship between the court and the legislature. I feel like I can step back a little bit. I've seen the relationship between the court and the legislature really be strong in the last 20 years. To answer Mr. Breslin's comment, the Chief Justice has been committed. We've seen it work through tort reform. We've seen it work with a number of bills where the legislature sets the policy for something and the court implements it with its more deliberative process of the Supreme Court Advisory Committee. I did some research before. I know I'm only at 30 seconds. I did some research since the court has had this authority in the 1940s. They have only used this provision that you're repealing 11 times since 1939. As far as I can tell, 7 of them were with actual legislative approval. They have only used this authority 4 times in the last 35 years on relatively non-controversial things. Senator Hughes, Chairman Hughes, I can give you my research if you would be interested in it. So you may say that the fact that the court rarely uses it means that it's not a big deal to repeal it, but I still am here to testify against it for this reason. It's used so little, and in part because of what Mr. Breslin said about now there are provisions that the legislature puts in there, but it can be a real stopgap. And I know y'all work so hard on things that you enact here, but the process over here is a little fast and furious, especially for my appellate brain. And the Supreme Court Advisory Committee process is very, very deliberate, like almost painstakingly deliberate. And so if the legislature ever did make a mistake, then it's a nice stopgap for the court to be like, oof, I think you didn't think how this was going to work. And I'm just going to give you an example as the last one that was done, if you'll just give me a little bit of time since I did all the research this weekend. So the last time it was done was in 2013, over 10 years ago. And it was when we were revising the justice rules. So we did kind of a big overlap of revising the justice rules to make them more efficient for the everyday Texan to be able to come into our justice court system. And in there, we noticed in the statute, it had a time frame of 6 to 10 days from service. And that's a little foreign in the Texas rules of civil procedure as it relates to county courts and district courts. And because those are typically 7 days, 14 days, 21 days, for whatever reason, they're nominals of 7, right? And so the court did change 6 to 10 days to 7 to 14 days to more comport with the other rules of civil procedure. That was the last time it was done. We gave notice. This is a notice provision. It just required, the Texas Supreme Court just needs to give notice to the legislature, the Secretary of State. It was done. That gives the legislature an opportunity to then, if you really are set on 6 to 10 days, you can fix it. You can change it back. But it just allows for some uniformity when we're doing some big projects like that too, as well as the stopgap. So I'm sorry. Thank you so much for giving me a little extra time. And like I said, I'd be happy to give you the specific dates of when this power has been used by the Texas Supreme Court.
No, thanks for your testimony. Members, any questions for the witnesses? I'll say the example you gave makes me want to pass this bill.
Okay.
That's our job. That's our job. We make the rules. They call balls and strikes. But really, thanks for your testimony. I know you from your work. We appreciate you. I know you're an excellent lawyer and you know what you're talking about. But we think it's a matter of separation of powers. But thank you. I'm speaking for myself, not for the committee. Anybody else got questions? Thank you for your testimony. Thanks for being here. Thank you. anyone else present wishing to testify on, for, or against Senate Bill 2275? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. I'll ask for the members of the committee and those watching at our intent to stand in recess close to 1:30 to allow time for the Senate services to set the tables and members to do other committee work. So we do plan on coming back after the Senate adjourns or recesses this afternoon. We'll try to get a couple more bills with limited witnesses so they won't have to wait around. The chair at this time lays out Senate Bill 1725. Senate Bill 1725. Under the law today, Section 106.12 of the Alcoholic Beverage Code about expunction of conviction or arrest for a minor is interpreted by prosecutors to mean that only one incident involved in an alcohol citation can be expunged. So what commonly occurs is the stacking of charges on one contact or incident with law enforcement. For example, if a college student gets a public intoxication violation, minor in possession of alcohol violation, and an open container violation, all on one incident report, the current interpretation of the statute is that only one of those three violations can be expunged. So it seems like an absurd result and not consistent with what was intended. So we want to make sure the law is clear because all violations are really part of one incident. So Senate Bill 1725 would allow first-time minor offenders who have multiple violations linked to one incident to have the ability to have the entire incident expunged. Again, this expunction is an option available. Courts involved. There's a long process. This would not require, but it would allow expunction in those cases. That's what the bill does, and I'll yield for your questions. The chair calls William Carter. We'll open public testimony. The chair calls William Carter. And welcome.
Afternoon.
Welcome. Introduce yourself and give us your testimony.
Thank you. My name is William Carter. I'm the Chief Juvenile Probation Officer in Lubbock County. In Lubbock County, we have a little bit of a unique program where we have, through interlocal agreement between the municipal court and juvenile probation, we put a juvenile probation officer in the municipal court, not only handling the traditional juvenile age population, but the alcohol docket too. And what we have seen across the state is some interpretation of that particular incident where, as you described, multiple violations. Through the alcohol docket, though, some DAs and judges look at it that it should just be one violation. But if they have two or three stacked on them, that they can't go through the expungement program. We ask that this get passed so that these young adults that have multiple violations, just one incident, can go through that expungement alcohol docket.
Thank you for your testimony. Senator Perry, do you have a question? You're recognized.
I'm just going to recognize a dear friend and a very quality director of some of the toughest kids in the state, specifically making it more of an incident instead of multiples. Gives that kid, let me ask it this way. Do you have a lot of repeat offenders? In other words, if we do this the way I think it should be done, and I think the way the chairman is, will you see a decrease in kids showing back up?
Especially for the college kids that are first-time offense, don't see very many repeaters. It's a very, very rare instance that once they go through the alcohol docket, they don't come back.
All right.
You know, they've got a career ahead of them.
Right, and that's the point. I think more of a redemptive kind of, one strike, you're okay, but it's stacked against you and haunts you for life in today's world with the record retention and the ability to pull and job applications and all kinds of stuff. So
absolutely.
Thanks appreciate what you do.
Thank you very much.
Senators, any other questions for the witness? Ms. Carter, thanks for what you do. Senator Perry said it well, but you're protecting the public while you help individuals, and we have to weigh all these factors and help them get on with their lives as we've learned lessons. So thanks for what you do. Thanks for being here to testify.
Thank you for carrying this.
Yes, sir. Thank you. anyone else present wishing to testify on, for, or against Senate Bill 1725? Seeing none and hearing none, public testimony is closed, and the bill is left pending at this time. It is the chair's intent for us to stand in recess here in a moment and then return 15 minutes upon adjournment or final recess of the Senate this afternoon. So we'll be voting on pending business right away and then moving on with the last couple of bills on today's agenda. At this point, members, is there anything else to come before the Committee on State Affairs? Very well. The Senate Committee on State Affairs stands in recess until 15 minutes after adjournment or final recess of the Senate this afternoon, and I'll be making an announcement as well. Thank you all.